Hello, I'm Peggy Strode with the Real Estate Sales Academy. Some of you may currently be in class right now, and some of you may have already passed the class and are awaiting the state exam. So we're going to give you a little review session. Obviously, we can't cover all of the topics that are included in your 75-hour broker pre-license course, but I'm going to go over some of the topics we feel are important and hopefully refresh your memory to help you study for the exam. A couple things to remember as you study and as you are taking the exam. Definitions are vitally important. Make sure you know your definitions. If you know your definitions, it'll give you a leg up on answering many of the questions. Any opportunity you get to take practice questions, whether they were quizzes given to you in the course, whether they're the answers, the questions in the back of the chapters or in the back of the book, take advantage, because the more practice you get answering questions, the better off you will be on the test. As far as the tests, they are timed, so make sure that you watch your time. Don't spend too much time on one question. If you don't know the answer, come back to it later. Also, never leave anything blank. Even if you do not have any idea, take a guess, because you got a 1 in 4 shot of getting it right. So never leave a question blank. Your first gut instinct is normally your best. Don't start second guessing yourself, because normally your first gut instinct is the right one. Read the questions, read the answers, and then read the questions again to make sure that you don't miss anything important that is included in the question. Now we'll move on to a review. As far as definitions, there are definitions that are important to understand the distinctions between. For example, your definition of land, your definition of real estate, and your definition of real property often get confused. The definition of land includes the Earth's surface to the center of the Earth and upward to infinity. This also includes anything that is naturally attached to the land, like trees, water, vegetation. Then to that land, you add on any man-made improvements. And once you add the man-made improvements onto the land, now you have your real estate. A man-made improvement would be a home, a fence, sewers, streets, etc. Then onto that real estate, you are going to add your bundle of legal rights. And these bundle of legal rights, these are your rights of ownership of the property. Once you add the bundle of legal rights onto the real estate, then you have real property. So property consists of different facets. In most cases, when someone transfers title to their property, they transfer all their rights to the property. But that doesn't necessarily have to be the case. Someone could transfer their property but retain some of the rights, or they could sell the different rights to different parties. For example, if I owned a property and I had oil underneath the property, I could sell the oil rights to one party, I could retain the surface rights, I could sell the other subsurface rights to somebody else, I could sell the air rights to somebody else. So 4 different parties could have ownership interest in that one parcel of real estate. So if you see a question, when you transfer title to real estate, do you have to transfer all of your rights? The answer is no. You can retain some of them, you can transfer them amongst different parties. So you have economic characteristics of land, and your economic characteristics of land are scarcity. There's only so much land, you can't make any more. What is there is there. Improvements, again, man-made indices. Permanence of investment. Permanence of investment means that there is an item that has been put on the property that is going to last for a really long period of time, like underground sewers, streets, etc. And the most important one is situs. This is also referred to as area preference, and you might think of it as location, location, location. It's people's preference as to where they want to live, and that's the most important economic characteristic of land. You also have 3 physical characteristics of land. You have immobility, which means land cannot be moved. You can alter the topography of land by a natural occurrence such as an earthquake or a volcano, but you can't actually move the land. Land is also considered to be indestructible. Remember the definition of land. To the center of the earth and upward to infinity, you can't totally destroy the land. Also, land is unique. Uniqueness is your 3rd physical characteristic. Every parcel of land has its unique characteristics. Even if they're almost identical, at the very least, each parcel of property has a separate piece of land. So, we're going to talk about fixtures. Fixtures are attached to the real estate, and they will automatically transfer along with the real estate, as opposed to personal property. Personal property is removable. So oftentimes there is confusion in the sale of a property over whether an item will go or whether it will stay. And so it's very important to make sure that this is addressed in the sales contract. So, for example, if you have bookcases on either side of the fireplace and your buyer goes to put an offer in on this property, and you just assume that these bookcases are attached and that they're going to stay with the property, maybe the seller thinks otherwise and plans to remove them. So if the seller removes those and the buyer expects that those will be staying, you could have a problem when you get to the closing. So in the event that a court looks at, this goes before a court of law, and somebody tries to sue someone else because they took an item that they expected to stay, the courts are going to look at 5 things to determine whether or not an item is a fixture or it is real property and able to be removed. They're going to look at the method of attachment and the adaptation to the real estate. In other words, how is this item attached to the real estate? When you moved it, did it leave a big hole in the wall? If it did, it probably should have stayed there. They're going to look at the relationship of the parties. Are you talking about a landlord-tenant relationship, or are you talking about a buyer-seller relationship? The laws are a little bit different in regards to those 2 situations. You're going to look at the intent, or the judge is going to look at the intent. How was that item intended to be used? Was it intended to be used as personal property or real property? But the most important thing that they're going to look at is the agreement of the parties. In other words, what does the contract say? So again, important to make sure that these types of items are included in the sales contract. Trade fixtures are another category of fixtures that are a little bit different. These are for use in a commercial lease, in a commercial business. For example, if we are going to rent a space, and when we rent this space, we have 4 walls, a floor, and a ceiling, and we're going to use this for our commercial business. So we're going to come in and we're going to put our ovens, our booths, our walk-in refrigerators, because maybe we're opening a restaurant bar. When we bring these items in, these items are going to be permanently attached to the structure. However, they are not your normal fixtures. These are going to be called trade fixtures. Trade fixtures are for use in a commercial business, and they remain the personal property of the tenant. However, trade fixtures must be removed by the last day of the lease, and if they are not removed by the last day of the lease, then they become part of the real estate, and now they are going to become the property of the landlord. You have certain benefits to home ownership. As one pays into the mortgage into their property, they build up equity in their property. And equity is in someone's property is the value that they have in the property. The market value of the property less any mortgage or any other liens associated with the property will give you homeowner's equity. So you build up equity as you pay into your mortgage every month. There are also tax benefits. So a homeowner can deduct interest up to $750,000 in the sale of their principal residence. If it's a loan that they had prior to 2017, they can deduct $1 million in interest. Up until 2025, interest on second mortgages are no longer deductible. Also, you can deduct on your income taxes, your real estate taxes, only up to $10,000. Under the Taxpayer Relief Act of 1997, it is now allowed for a homeowner, an individual homeowner that is selling their home, to avoid paying capital gains tax on the sale of their primary residence, up to $250,000. So if a single homeowner sells their property, prior to 1997, they might have to pay capital gains tax on any gain that they had seen in this property. However, with this Taxpayer Relief Act, up to $250,000, they no longer have to pay any capital gains tax. For a married couple that is filing jointly, they are excluded from paying capital gains tax for up to $500,000 of value. So if someone that is married filing jointly sells their property and they have a gain of $600,000 on their primary residence, they would only have to pay capital gains tax on $100,000. You don't have to be any age to use this exclusion, and you can do it repeatedly throughout your lifetime. A 1031 exchange is a little bit different. In a 1031 exchange, it allows for the deferment of capital gains tax. So for example, if someone has an investment property and they would like to sell that property, and again, since it's not their primary residence, they would not be able to apply for the exclusion. So if they sell that property, they're going to have to pay capital gains tax on it. However, what the 1031 exchange allows is for someone to exchange investment properties, not to avoid paying capital gains tax, but to defer those taxes until that property is later sold in a taxable transaction. So for example, if I had 2 single-family homes, instead of selling one as investment properties, instead of selling one and buying another one, I could exchange them. Again, just to defer the capital gains tax until a later time. Next, we'll talk about the categories of licensure. And I'm going to bring you to the screen here. So I'll start with the bottom, the residential leasing agent license. That is referred to as a limited scope license because if one obtains this license, they're limited in what they can do. They can only lease residential property, they cannot sell property of any kind, nor can they lease commercial or industrial property. You have to be 18 years of age to get this license, and you have to take a 15-hour pre-license course and pass a state exam. The broker's license is what you are all taking right now or have just completed. You have to be 18 years of age to get your broker's license. That's something that changed in the law a couple of years ago. It used to be 21. Now you just have to be 18. You take a 75-hour course. That's the 75-hour broker pre-license course, and you have to pass a state exam to get that broker's license. Now, prior to your first renewal, you have to complete 45 hours of post-license education. Now, brokers will renew their license by April 30th of every even-numbered year. So prior to that first renewal, once you get your license, you must complete this 45-hour broker post-license course. Now, that will put you at 120 hours. Now, as I said, the first renewal, you have to take the 45-hour course. Subsequent renewals after that, every 2 years, you will be required to complete 12 hours of continuing education. Now, if anyone wants to, at some point, work on their own, not work for a sponsoring broker, open up your own company or manage an office, you will need to get that managing broker's license. And the total number of hours of education that is required is 165. So here's how that breaks down. Your 75-hour broker pre-license course, the 45-hour post-license education course, that puts you at 120. And then to get the managing broker's license, you have to take another 45-hour pre-license course, and you have to go and take and pass another state exam. Now, in order to get that managing broker license, you have to have had your broker's license for 2 out of the last 3 years. Now, managing brokers will renew their license by April 30th of every odd-numbered year. And prior to renewing their license every odd-numbered year on April 30th, they will need to complete 24 hours of continuing education. Next, we're going to discuss agency relationships. When you are representing someone, whether you're listing their property or you're representing a buyer in their purchase of a property, that seller or that buyer, whichever it might be, is your client or your principal. Someone for whom you are performing a small level of service for, but it doesn't rise to the active level of representation, is going to be a customer. Now, a customer is owed certain duties. A customer is owed honesty, fairness, accurate information, and reasonable skill and care. However, a client or a principal, someone that you are representing, are owed fiduciary duties, because when that person becomes your client, you enter into a fiduciary relationship with them, which means they have placed you in a position of trust and confidence. And once that happens, you owe them certain duties. And here are the duties, and you can remember them. These are very important to remember. You can remember them. If you look at cold AC going down the bottom there, or the side there, care, obedience, loyalty, disclosure, accounting, and confidentiality. Those are your fiduciary duties. So I'm going to give you some examples of both of them. It's very important for you to understand what these fiduciary duties are. So, first one is care. Means you take proper care of your client. Use your knowledge and expertise to guide them through the transaction from start to finish. Now, an example of care. Let's say that your buyer is going to purchase a property and they intend to use it for a specific purpose. Maybe they want to put a dog grooming business or something in this property. And you go ahead and sell them the property, but you don't check the zoning to make sure that that will be allowed. They move in and they can't do what they intended to do. They could come back to you and say you violated your duty of care. Obedience, that one's pretty easy. You obey your client as long as you don't break the law. So if your seller tells you, I don't want a for sale sign in my front yard because I don't want my neighbors to know that I'm going to move. Okay, you're going to obey that. It's not against the law not to put a sign in the front yard. However, if your seller tells you they do not want someone from a certain ethnic group coming through the property, you are obviously not going to obey that. The next one is loyalty. And loyalty is your most important fiduciary duty. What that means is that you put your client's interest above your own. A really good example of that would be this. If I have a buyer that I'm going to show properties to on Saturday afternoon, and they want a specific type of property in a specific area, so I go to the MLS and I pull listings that would suit their needs. And as I'm looking through the listings that I plan to show them, I notice the commission payout on all of them is a certain level, but there's one commission payout that is very, very low. So I kind of slip that one to the bottom of the pile and I don't tell my client, my buyer, about it. I just violated my fiduciary duty of loyalty to my buyer because I put my interest above theirs. The next one is disclosure. And disclosure goes into a couple of different levels here. First of all, any physical defect in a property must always be disclosed, whether you are representing the buyer or the seller. Now, a lot of this responsibility will fall on the seller because the seller is required to fill out an Illinois Residential Real Property Disclosure Report. On that, they're going to indicate whether or not they have lived in the property in the last 12 months and whether or not they're aware of any defects that are in the property. And they have to disclose that and sign that document. That report has to be made available to the buyer before they sign a sales contract. If the buyer does not get that so that they are fully informed of the defects that have been disclosed prior to writing the contract, and maybe they get it a week later, then at that point the buyer would have 3 days to back out of the contract if there are any negative disclosures on this report. So it's real important to make sure that all parties comply with this. Now, disclosure also goes into another category when we're talking about stigmatized properties. Now, stigmatized properties are properties that have something going on in them that gives a negative association or a negative feeling with the property, but it doesn't affect the physical property itself. So, for example, let's say that there has been a murder in the property or a suicide in the property. Important to remember, if you are representing the seller, you do not need to disclose that because number one, it doesn't affect the physical property itself, and number two, it is not in your seller's best interest to disclose that information. However, if you are representing the buyer, you have a duty of disclosure to your buyer to disclose anything you know that might affect their decision. So in this case, if you see a question regarding a stigmatized property, if you're representing the seller, no need to disclose, but if you're representing the buyer, you need to disclose that. Now, if you are asked about a stigma associated with a property, you can't lie, but you do not have to go forth and disclose it. The next one is accounting, and we'll discuss that a little bit further along in the session, but accounting deals with earnest money deposits on contracts and security deposits on rentals. There are strict rules as far as brokers holding earnest money, so we'll talk about that in a little bit. The next one, last one, is confidentiality. Confidentiality is owed to your client or your principal. So if your client or your principal gives you confidential information about their personal affairs, you cannot share that with anyone except with your sponsoring broker if you need advice and counsel, but then they have to keep it confidential as well. Confidential information will stay with you past the expiration of the agreement. It goes with you to your grave. You cannot ever share confidential information about your client with anyone. Now, it could be very harmful to your client if confidential information is shared. And the other thing that you need to remember is that confidential information is only learned in an agency relationship. So if you get information, personal information about someone that you did not get in an agency relationship, it is not confidential. Let me give you an example. I have a listing, and my seller has given me a lot of confidential information about herself pertinent to her affairs, maybe her reasons for selling, etc. I go back to the office and sit with my coworkers having lunch, and I start telling my coworkers about my client's personal affairs. I've just violated my duty of confidentiality to my client, number one. But here's the bigger problem. Now all of these agents have that personal information about my client. What happens if 2 weeks later, one of those agents has a buyer for that property? They know stuff that would benefit their buyer, right? So the question is, can they tell their buyer the information I shared at the lunch table? And the answer is yes, they have to, because they didn't get it in an agency relationship. They have a duty of disclosure to their buyer, their client, to disclose anything that they know. So you have to be very careful that you keep information confidential. Confidential information will cease to be confidential, however, when it becomes a matter of public record. So we said you would be representing the buyer or the seller, and they would be your client or your principal. However, there is a situation where you could represent both the buyer and the seller in the same transaction. That is legal in Illinois. It is called dual agency. So in Illinois, a dual agency situation is allowed as long as both the parties, the buyer and the seller, agree to let you be a dual agent in writing before you begin to act as a dual agent. And also, a second written confirmation of that dual agency consent is required at contract signing. It's written right into the sales contract. So what's important to remember is that if you act as a dual agent, both parties are giving up some of their fiduciary duties, because you cannot be equally loyal to both parties. What it means, as a dual agent, you can merely pass information back and forth between the parties. You can no longer give either client advice or counsel. So if the buyer asks you when they're writing a contract, what do you think I should offer? You can't answer. Put down what you think. If the seller asks you, do you think the buyer will offer more money? You can't answer that. So they have to understand that they are giving up some of their fiduciary duties. Now, the advantage, as most agents will tell you, of being a dual agent is that you get both sides of the commission. A second advantage is that sometimes, unfortunately, when you're involved in a transaction, the other agent on the other end of the deal might be difficult to correspond with or to communicate with, and agents will like the dual agency situations because they have more control over the situation and they can handle it and get answers back and forth. So dual agency, again, is legal in Illinois as long as all parties agree to it. Now, there are another agency relationship that we will talk about is designated agency. In Illinois, we are a designated agency state, and what that means is that any agreement you take doesn't belong to you, it belongs to your sponsoring broker. So for example, if you take a listing, you're taking that listing on behalf of your sponsoring broker. You don't own the listing. The listing is signed by the designated managing broker on behalf of the sponsoring broker and the seller. You're going to sign it as well, however, you are the designated agent. So the agreement belongs to the broker. They designate you as the agent to handle the deal. Now, if a sponsoring broker has one agent that has the listing and another agent that has the buyer for the property, well, the sponsoring broker owns both of those agreements. However, because of designated agency, the broker has designated two different agents to handle two separate sides of the deal. The sponsoring broker is not deemed to be a dual agent. So you can create an agency agreement by express agreement or by implied agreement. An agency agreement created by express agreement means it was created in words or in writing. An express agreement means it's words or writing. An implied agreement, a little bit different. It means your words or actions imply a relationship. Now, that can get you into trouble because, let me give you an example. If you are doing an open house for your seller is your client, you owe your seller fiduciary duties: care, obedience, loyalty, disclosure, accounting, confidentiality. Okay, someone walks into your open house and you give them basic information about the property, the room sizes, the school district, the lot size, heating bills, whatever. You're just performing a small level of service. It doesn't rise to the active level of representation, so that person is a customer to you. So as you're showing this customer, maybe a potential buyer, through the property, you make a comment such as, you know what, my seller is very anxious to sell this property. If you put an offer in for $10,000 less, I think I can get him to take it. Well, first of all, you just violated your fiduciary duty to your seller because you gave confidential information to that customer, okay? And you sure didn't take care of them either. Now, the other part of it is you just implied to that buyer that you're working in their best interest, that you're working as an advocate by them by giving them information that would benefit them. So what just happened here is you became their agent. Now, you're already representing the seller, you just became an agent for the buyer. You're a dual agent, and it's undisclosed and it's illegal. So you can get yourself in trouble with that. Okay, some other agency terms to look at here. A general agency. General agency is the relationship that you will have with your sponsoring broker once you go to work, and a property manager is also a general agent. A universal agent is someone who would take care of all the affairs of someone else. For example, grandma with dementia in the nursing home. In order to be a universal agent in Illinois, you have to have written power of attorney. A special or specific agent is the relationship that a broker will have with a client. They're representing them in just one special or specific situation. Okay. When you get your license, you will be most likely hired as an independent contractor. There is nothing in the law that says you cannot be hired as an employee, but most brokerage firms, the vast majority, I'd say 99% of them, will hire you as an independent contractor. So as an independent contractor, you're basically starting your own business under the sponsoring broker. Now, the sponsoring broker is responsible for training you and making sure that you know what you're doing, and for that, they will take a cut of your commission. But you, as an independent contractor, will then be responsible for paying your own taxes, your self-employment taxes, your Social Security, etc. As an independent contractor, you're able to write off certain items. You'll have to check with an accountant to see what it is you can write off as far as that goes. But when you get your commission check, you're going to get the whole check. Okay, then you're responsible for everything else. Now, E&O insurance is an important topic to cover. Errors and omission insurance is kind of like a malpractice insurance for a doctor. It's not required by law that you carry E&O insurance. However, it is going to most likely be the requirement of your brokerage firm that you carry it. Most brokerage firms will require their licensees that work there to carry E&O insurance as a condition of their employment at that company. Talk a little bit about antitrust laws. Antitrust laws pertain to competing brokers competing for business in the open market. It's designed to prevent monopolizing the competition. So there are 5 categories that we'll look at as it pertains to real estate licensees. So first one is price fixing. You have to make sure when you are talking with a seller regarding commission, for example, that you do not make any comments that would indicate that prices are standardized in the market or that they're fixed. So you cannot make a comment to a seller, I will only take a 5% commission because that's what everybody takes. Or I will only take a 5% commission because if I don't at least pay 2.5 out through the MLS, nobody will look at your property. That's an implication that the prices are fixed, and that's illegal. That's a Sherman antitrust violation. What is allowed, however, is for you to make a statement such as, I can only take a 6% commission or a 4% commission is the lowest I can go because that is my brokerage company's policy. That is perfectly legal. But to indicate that amongst brokerage companies in the area that this is a standardized rate is a violation of the antitrust laws. Next one is group boycotting. You cannot boycott a certain broker in the area to try to put them out of business. So for example, if 5 brokers that are friends get together, competing brokers, and decide not to show a 6th broker's listings to put her out of business because she pays out a low commission rate or for whatever reason they don't like her, that's illegal. That's a Sherman antitrust violation. Allocation of customers or markets is the next one. Let's say that 4 different brokers, competing brokers in the area, get together and decide, you know what, instead of always competing for each other's business, let's do this. Let's divide up the markets. Broker A, you take north, broker B, you take south, etc. That's illegal under the antitrust laws. You're monopolizing the competition. Now, within a brokerage company, and watch this in a question because this is a question that comes off quite frequently. If you have brokers within a company and they're getting together, for example, to do some marketing, they can split up the areas. You take this area, you take this area, and divide up the areas. That's perfectly legal. Why? Because they work for one broker. It doesn't deal with competition amongst competing brokers, so that's fine. Next one are tying arrangements. A broker cannot have a listing and condition the sale of that listing upon a purchase of a property down the street that is not quite so nice. So that is illegal. He's tying in one property to another. Disparaging the competition. Not only would this be a violation of the antitrust laws, but it also would be an ethics violation to disparage your competition, talk badly about your competition, because it can be seen as an effort to put that broker out of business, kind of under the group boycotting. So those are your categories under your antitrust laws that would be good to know those. There is a national do not call registry. And if someone is on the National Do Not Call Registry, you cannot call them to try to solicit their business. However, there is an EBR or an existing business relationship for brokers. For example, if you have a listing and that listing has expired and you want to go and call that prior client to try to solicit their listing again, you can call them even if they are on the Do Not Call Registry for a period of 18 months. So not only can you call them, but so can anybody else in your brokerage company, because who owned the agreement? The sponsoring broker. So up to 18 months after that listing has expired, you can contact them unless they ask you not to. If they ask you not to, then their name has to go on an internal Do Not Call list, and now you can't call them. Also, if someone calls you to make an inquiry about a property, and they are on the do not call registry, you can call them back for 3 months after that inquiry has been made. The Can-Spam Act deals with commercial emails, and there are a few things to remember about the Can-Spam Act if you are going to send commercial emails. Deceptive heading lines are not permitted. False advertisement is not permitted. You have to have an opt-out method to allow people to opt out of receiving future emails, and you have to have a valid physical address. This can be a P.O. box. Okay, next we'll talk about brokerage agreements. So, as we said earlier, you're either going to be representing the buyer or the seller. If you're representing the seller, you will enter into a listing agreement with that seller. So, the most common listing agreement, and probably the only one you will ever take in your real estate career, is an exclusive right to sell listing. With an exclusive right to sell listing, the seller is exclusively hiring one brokerage firm to represent them in the sale of their property. Now again, you are the designated agent for that brokerage firm. What that means is this is the best guarantee that you will receive compensation, because if that property transfers title at any point while you have it listed, you're owed your commission. Now, the way that you would receive the commission for that, the listing broker would have to sue the seller in a suit for earned commission. So for example, if you have a 6-month listing with your seller, and your seller gets a knock on the door from her neighbor that says, my daughter wants to buy your house, seller can't cut you out. They have to tell the neighbor to contact you, their agent, and handle it that way. So it's the best protection for a broker, it's the best guarantee that you will get paid. Now, the other exclusive agreement is an exclusive agency agreement. It is still an exclusive agreement, meaning that the seller is exclusively hiring one brokerage company to represent them in the sale of their property. However, they are also reserving the right to find their own buyer. So if they find their own buyer, the broker is going to be cut out and won't receive any commission. So in that previous example I gave you, where the neighbor comes to the door, if you have an exclusive agency listing, they can cut the broker out. So if you ever see a property that has a for sale by owner sign and a real estate company sign in the front yard, that's most likely an exclusive agency listing. It's unlikely that you'll take those, because in an exclusive agency listing, you're still doing all the work. You still have an exclusive agreement, but the difference is you may not get paid, because the right is reserved by the seller to find their own buyer. The other type of listing is an open listing agreement. Not commonly found around in urban areas, might be more so in rural type areas, but with an open listing, the seller is going to hire any number of brokers and reserve the right to find their own buyer. So in an open listing, you'll have a for sale by owner sign and maybe 4 different real estate company signs in the front yard. So basically, the only way you get paid on that one is if you're one of the brokers and you bring the seller the buyer before any other broker does, or before the seller finds the buyer themselves. Open listings are not allowed to be put into the MLS. Next, we have a net listing. And in net listings, you're going to guarantee the seller X amount of dollars from the sale of their home, and you're just going to list it for something over that and keep anything over that as commissions. So if a seller says, I want $200,000 out of my house, and you say, okay, fine, I'll list it, and anything over that I'll keep as commission. Well, maybe they're misinformed, or maybe the house is worth $250,000. So in that event, the seller is not going to get what they really deserve out of the property. Even though net listings are legal in Illinois, they're frowned upon, they're considered to be potentially unethical, but they're still legal. So you could see a situation where somebody could be taken advantage of in a net listing situation, and there have been lawsuits filed against agents for doing just that. On the other side of the coin, if you're representing the buyer, there are different buyer agency agreements out there as well. So you have your exclusive buyer agency agreement. That's kind of like the exclusive right to sell listing agreement. the buyer is hiring one agency exclusively to represent them in the search for their home. And there can be a clause in there that will guarantee payment if they find it outside of the agency. The exclusive agency buyer agency agreement, I know it's a lot of words, that's kind of like the exclusive agency agreement on the listing side, where the buyer is going to hire one brokerage company exclusively, but they're going to reserve the right to find the property themselves and not be obligated for any payment of commission. And then you have the open agency, buyer agency agreement, where a buyer will hire any number of agents, and basically whoever finds them the property first is going to be involved in that transaction. Now, another term to talk about is contemporaneous offers. A lot of people get contemporaneous offers confused with dual agency. It's a totally different thing. So dual agency, remember, is when you're representing the buyer and the seller in the same transaction. Contemporaneous offers means you have two buyer clients, and both of these buyer clients want to purchase the same property. That's okay, you can do that, but both buyers have to be given a notice, and it's called notice of contemporaneous offers. Have to be given notification that you're representing somebody else, and they both have to agree to it. And if you are representing two buyers in a contemporaneous offer situation, obviously you have to be careful and can't give either buyer any information about the other. So either one of these buyers can be uncomfortable with this situation and request other representation. But it is legal to do that. Okay, we'll talk a little bit about government powers. So your four government powers are, you can remember them by Pete. The first one is police power, and that's the state's power to, or authority to enforce laws. And the way that the state will pass on that authority to the lower forms of government is through enabling acts. So that's to protect the public and the general welfare of the public. Eminent domain. If you have a property and the government wants your property for an intended use, for example, they're going to build an interstate through and they need your property, they're allowed to take your property through eminent domain. They have to compensate you, just compensation, which can always be litigated later, but you're not going to have any choice. You're going to have to give up your property. And the actual process by which they take the property is called condemnation. Then you have taxation, and I think we all know what that is. They tax you. It's a way a government can raise money by taxing the citizens. And escheat. If someone dies in Illinois without a will and there are no identifiable heirs, real property that this person owned will escheat to the county where the property lies. It doesn't go to the state, it will go to the county by the state's power of escheat. So next we are going to look at the estates and land. So the best way that I can break this down for you is to have you go through the chart here with me. So these freehold estates here, this is actually one half of the chart. The other half of the chart is your leasehold estates, which we'll talk about later. But freehold estates means that there is some form of ownership involved. So over here, under your fee simple estates, the first one is your fee simple absolute estate. That is your highest form of ownership. Most people own their property as a fee simple absolute estate. So that means you own your property. You can do whatever you want with your property as long as you don't break the law, right? It's yours. There are no strings attached to your ownership. Next, we have your fee simple defeasible estate. Now, if you have a fee simple defeasible estate, you still own the property, but there are strings attached to your ownership. Either there's a limit on how you use the property, or there's a condition that you can or cannot perform while you own it. So, for example, the first category there is a special limitation with a possibility of reverter. That's also called a fee simple determinable estate. So, I have a property, and I'm going to give it to you. Property's yours, but I'm going to place a limit on how you use it. Property is yours as long as, or while, or during you use it for religious purposes. If you cease to use it for religious purposes, title is automatically going to revert back to me. You're going to lose the property. Now, the verbiage is a little misleading because it says special limitation with a possibility of reverter. There's really no possibility. If you break the limit that I've placed on the property, you're going to lose it. Title's reverting back to me. Now the next one is conditions subsequent with right of reentry. And I always use the example, I give one of my kids a property on the condition that they don't have drugs, alcohol, wild parties on the property. Who owns the property? The child I gave it to, right? But I placed a condition on it. Here's the thing. If they break the condition, I can take the property back. However, with conditions subsequent, I have to go to court to get it back. Okay? So in either of these scenarios, there's still ownership of the property, but there's strings attached to the property. Now, over here we have life estates, and there are 3 of them. There's a conventional life estate with reversion or remainder, there's pour or vie with remainder or reversion, and there's a legal life estate. I'm going to go to legal life estate first. There are 3, dower, curtsy, and homestead. Pretty simple. In Illinois, we do not have dower or curtsy. What we have in Illinois is the homestead estate. And what that is, that's the legal life estate that one has in their permanent resident, their residential property. In the event, because of your homestead estate, in the event that a property is forced to be sold in a court-ordered sale, if that were to happen, to satisfy a debt, a judgment, something like that, the first thing that is always going to be paid are your real estate taxes, first and foremost, and any special assessments that are attached to the property. Then in the order of priority of liens, anything that attaches to the property, like your mortgage, your second mortgage, a mechanic's lien, that all gets paid off. Then, before any unsecured debts are paid, judgments, credit cards, etc., the homeowner gets some money. That's their legal life estate. An individual will get $15,000 before any of those unsecured debts are paid, and a married couple will get $30,000. Now, the married couple do not, both spouses do not have to be on the deed. So for example, let's say the husband owns the house, he's married, they both live in the property, but the wife's not on the deed, she still has the homestead estate, they still get the $30,000. So that is why when a property is bought by a husband and wife or a married couple, or if sold by a married couple, both spouses will have to sign all the documents, all the paperwork, because even though both are not on the deed, or not on title, they both have an interest in the property because they have the homestead rights. Okay, then you have your life estates. Let me explain it to you this way. Let's say dad has a property and he is going to give it to his daughter. But what he's going to do is he's going to give her a life estate. So what that means is he's giving her the property and she owns it for as long as she's alive. When these are set up, they have to be either set up with a remainder estate or with a reversionary estate. So if dad sets this up as a reversionary estate, if his daughter dies, it's going back to him, okay? Or he can set up as a remainder estate, which means if the daughter dies, it will pass to someone else, son, cousin, whoever, okay? The question is, who owns the property? The daughter does. Till when? Till she dies. So what that means is she cannot will the property to anybody, because when she dies, it's going back to dad or it's passing to a third party. She can also not destroy it. Now, she does own the property. So what that means is she can take out a loan on it, she can make improvements on it, she can sell it. If she sells the property or leases the property, she can do that. But the original provisions of the life estate are going to remain intact. So let's say the daughter moves, she's going out of town, and she sells it to A. A buys the property, but it's on title, it's a disclosure item. A buys the property knowing it's still based on the daughter's life. So if the daughter gets hit by a bus going out of the closing, A's going to lose the property. It's either going back to dad or it's going to a third party. So A's going to want some assurance that her interests will be protected in the event that the daughter dies. So normally they work that out with a life insurance policy negotiated as part of the deal. That doesn't happen a lot. Probably will never be encountered in your real estate career. In the event it does, this is a job of a skilled real estate attorney. So same thing, if the daughter moves out and leases it to A, A's lease is going to be cut short if the daughter dies. So that's a life estate. Now the question comes up oftentimes, let's say that Dad gives the property to A, and if she dies, it goes back to him. So the question comes up, what happens if Dad dies first? Well, when this is set up, there would have to be a provision to whom that future interest would go. So maybe it's the wife or somebody else that he knows. So if Dad dies, it would move on to the next party that he's indicated. Okay? Now, that's a conventional life estate with remainder or reversion. One thing that I think might help you understand this a little better, let's say we have Dad giving the daughter the property. Maybe the daughter is married, and maybe Dad doesn't like the husband, and she's married. So the way she married this guy, so they're in the house, right? But if she dies, Dad doesn't want him to get it, because the way you hold title to real estate will supersede any will or any heirs. So if she dies, the husband's not going to have any claim on it. It's going to go back to Dad. So that's one way that he can control that. Now, the next category here is the life estate per ordre vie. So we'll use the dad again. And let's say that he's going to give his daughter this property. But the reason he's given the daughter the property is that he wants to make sure that his grandson who is ill has a place to live. So he gives the daughter the property as a life estate, but he's not going to base it on her life. He is going to base it on the life of the grandson. So if something happens to the grandson, Dad's going to take it back. So that's a life estate per ordre vie, based on the life of someone other than the life tenant. Next, we'll talk about liens. So liens can be classified as either voluntary or involuntary, general or specific, equitable or statutory. So a lien, remember, is a money encumbrance. It has to do with money. So for example, the best example of a voluntary lien would be your mortgage. When somebody goes to take out a loan, they do that voluntarily. They voluntarily give the lender the right to put a lien on their property. Your real estate taxes, those are involuntary. You sure don't want them. Somebody files an IRS tax lien on you, that's involuntary. You don't want it, right? Liens can also be general or specific. A general lien will attach to all the debtor's property, both real and personal property, and a specific lien will only attach to one piece of property. For example, your real estate taxes, those just attach to one property. Your mortgage, that attaches to one property. If there's a mechanics lien, just to one property. If there's a judgment filed against you, that's going to be a general lien, because a judgment is a general lien and it will attach to all real and personal property in the county where the judgment is recorded. So in other words, if there is a judgment recorded in Cook County and the debtor has property also in Lake County, in order for the judgment to be effective in Lake County, it has to be recorded there as well. Liens can also be equitable or statutory. Statutory lien means that the purpose for which the lien was created was by a court decision or a law. Equitable lien, think of it as a case-by-case basis, created in a courtroom based on the concept of fairness. So I'll give you a few examples here. Your mortgage, that's a voluntary lien, right? It's specific and it's a statutory lien. Somebody files a judgment against you. That's involuntary. It's a general lien. And that one is an equitable lien, because the judge will look at all of the information and decide whether or not it's right to put a lien on that property, a lien against you. So that is going to be a equitable lien based in a courtroom on the concept of fairness. Your real estate taxes, we don't want those. They're involuntary. They're specific and they're statutory as well. You have work done on your property and you have a dispute with the contractor. He files a mechanics lien against your property. Involuntary, specific, statutory. So The other type of lien that can be either voluntary or involuntary would be a special assessment lien. So if you are notified that the municipality is bringing Chicago water into your area and you're all going to be charged a portion of that, well, that's involuntary, right? But a special assessment can be a voluntary lien. So you get together with your neighbors and you decide to all chip in and put streetlights in your subdivision, that you do voluntarily. So, talk a little bit about real estate taxes. So there are exemptions to the real estate taxes. You can have a deduction or have your taxes reduced if you are living in your property, and that is called your homeowner's exemption. Do not confuse that with the homestead estate that we talked about earlier. Remember, the homestead estate is the amount of money reserved in the family home in the event of a court-ordered sale. It was the $15,000 for an individual and $30,000 for a married couple. The exemption is different. If you live in the property and it is owner-occupied, you will get a reduction on your real estate taxes. That's your homeowner's exemption. You also have the senior citizens exemption. If you were over the age of 65, you get a reduction on your taxes as well for living in that property. There's the senior citizens exemption freeze. That allows Illinois seniors to freeze their taxes once they've reached 65, as long as their income doesn't exceed $65,000 a year. So those can be frozen for the duration of their life, provided that that income stays below $65,000. And there is also the improvement, homeowners improvement. You are allowed to forestall an increase in your taxes if you have an improvement of your property up to $75,000 for 4 years. So those are different ways that your taxes can be reduced. If someone does not pay their real estate taxes, their taxes can be sold at a tax sale. So, for example, if taxes are not paid by the due date, they will give you notice, and they will give you, there will be notice in publications. In Illinois, you'll get you have until January 2nd to make sure that your taxes are paid. If not, you will get notice normally by the end of January, and if they are still not paid, they will go to a tax sale, which normally will be in June. And what happens at an annual tax sale, and this is important to remember, it's not the property that is sold at an annual tax sale, it's the unpaid taxes. And the unpaid taxes are sold to the bidder that bids the lowest rate of interest. So competitive bidding will start, and people will bid down to pay your taxes for you. And the one that bids the lowest rate of interest will win and get to pay your taxes for you. What that means is that the interest rate that they bid is the interest rate you will have to pay them to redeem your taxes. And a homeowner will have 2.5 years on owner-occupied property to redeem their taxes by paying the purchaser or the successful bidder the interest rate that they bid. If the property does not sell at an annual tax sale, it will go to a forfeiture sale, and a property that has been the taxes have not been paid on for 2 or more years that have not been sold at a tax sale can go to a scavenger sale. In a scavenger sale, the actual property is then sold. But just remember, at an annual tax sale, it is not the property that is sold. It is the unpaid taxes that are sold to the party that bids the lowest rate of interest. Other liens, mechanics liens, are liens that will be imposed by someone doing work on your property if there is a dispute over payment of the bill. So for example, you have a contractor that is putting a room addition on a property, and what most people don't realize is that the contractor is required to give a sworn statement to the homeowner listing all of the names of the subcontractors that they're going to use on the job. And it is the responsibility of the homeowner to get releases of lien releases or waivers from these subcontractors, because if the homeowner doesn't have that, when the work is completed, if they pay the general contractor and then the general contractor doesn't pay the subs, if you don't have those lien waivers, the subs can come back on the homeowner for their payment. So Mechanics liens have to be filed within 4 months after completion of the work, and the date that the work was initiated or contracted for is the date that it attaches in the public records. And once the lien is filed in the public records, there are 2 years to enforce that lien. A lease pendens, that's Latin for litigation pending. That means that there's not a lien on a specific property at this point, but there's notice of a possible future lien. There may be one coming. And a writ of attachment, that happens when you have realty that is not otherwise mortgaged or encumbered. What the courts will do is they'll put a writ of attachment on that property so that the court will retain custody of that property until a lawsuit will conclude, so that the owner of the property can't dispose of that property before that's done. An IRS tax lien, that is a statutory lien, that is a general lien attaching to all your property, and it's involuntary. And the one thing I wanted to mention about that is most people assume that an IRS tax lien will go high in the list of priority. It doesn't. It goes in the order of priority of when it's recorded. If a commercial broker is getting ready to close on a property, under the Commercial Broker Lien Act, a commercial broker is allowed to place a lien on the property to ensure their commission. So if a commercial broker is uncertain, with this large amount of commission that might be due them, that commission will be there to be paid at the closing, they will place a lien on the property. But it's important to remember that the lien has to be placed on the property for the amount of their commission before you close. So obviously the buyer is not going to take the property with a lien on it, so that would have to be removed at closing. At closing it can be removed, or prior to, once the broker is comfortable that commission will be there for them. Okay, talk a little bit about contracts. So a contract can be express or it can be implied. So as we talked about before, an express agreement means that you've expressed your intention in words or in writing, and an implied agreement means that your actions imply that you are entering into a contract. So when you have a sales contract, it can be a verbal agreement or it can be a written agreement. That's an express agreement. Now, an oral agreement for a contract for the sale of property is valid between the parties. So if you and I enter into a contract and we do it verbally and we see that through to completion, that was valid between us. But an oral agreement for the sale of real estate will be unenforceable in a court of law. So in other words, if one of us gets unhappy and decides to back out, nobody could take the other to court to sue for performance. Good example of an implied contract. You go to a restaurant and you order a meal. It's implied you will pay the bill when you're done eating. You don't have anything in writing or discuss specifically. Contracts can be bilateral or unilateral. A bilateral contract means that both parties are obligated to perform, so your sales contract would be a bilateral contract. Seller agrees to sell the property, buyer agrees to buy it. A unilateral contract, only one party is obligated to perform, and a good example of that would be rent with the option to buy. If someone is leasing a property and they have been given the option to buy it at the end of the lease agreement, that's a unilateral contract, because if they choose to exercise that and they want to buy it, the seller or the landlord has to sell it to them. But do they have to exercise that? No, they've been given the option to. So it's unilateral. Only the seller is obligated to sell it to them should they choose to pursue that. So you have elements of a valid contract. You have to have offer and acceptance. You have to have consideration. One thing to mention, consideration is not earnest money. Earnest money is a buyer's good faith money that they put down on the contract to ensure the seller that they're serious about the deal and they're not going to walk away because they would risk losing their earnest money. Consideration is the sale price, what the property is being sold for, what is being offered for the property. You have to have legally competent parties. If someone enters into a contract and they truly believe they're Marilyn Monroe, that's not legally competent parties. Consent. All parties have to give their consent, and it has to be for a legal purpose. A contract for something that is illegal is not a valid contract. When you have a buyer that is writing a contract on a property, they want to purchase a property, and they fill out all the terms and conditions that they want included on the contract, and they sign it, you do not have a contract at that point. At that point, what you have is an offer to purchase. The offer to purchase then goes to the seller, and if the seller likes everything on that contract, they will sign it. Question is, do you have a contract then? And the answer is no. Until you have what we call notification back, you have no contract. So once the seller signs that contract in agreement with everything that the buyer has offered, the buyer has to be notified of the seller's acceptance. Up until that time, you don't have a contract, anybody can back out. Now, it doesn't always go that smoothly. Sometimes there are what we call counteroffers. So maybe the seller is not pleased with everything that the buyer has offered, so they will make some changes to the contract. They may change, for example, the price or the closing date. If they make a change to the contract, what they have done is they have created a counteroffer. And what a counteroffer does is it voids the offer that preceded it, and it makes a new offer. So the counteroffer is a brand new offer. So that first offer is off the table, it's gone, it's void. So these offers and counteroffers can go back and forth until all parties are satisfied, and until, again, you have notification back, you don't have a deal. So you can have a contract that is valid, void, or voidable, or unenforceable. So a valid contract meets all the essential elements of a contract that we talked about a minute ago. A void contract doesn't exist. And for example, again, a contract for an illegal purpose is void. Now, contracts can also be voidable. A voidable contract means that an aggrieved party has the right to say, I am voiding this out. Do they have to void it out? No, but they have the right to do so. Let me give you an example. I'm selling you my house, and I lie to you about the condition of my property. I misrepresent the condition, stating that it is in great shape. However, maybe I have foundation problems. I have misrepresented the condition. We enter into a contract, maybe a week or two later, you find out that I lied to you about it. The status of that contract at that point is voidable by you, the buyer, because you've been aggrieved. Now, do you have to void it out? No, you don't have to. So if you don't void it out, or up until that time that you void it out, it remains a valid and enforceable contract. So it's a valid contract, and we could carry it through to completion. The reason I say it's an enforceable contract is this. Let's say that that buyer who has the right to void it out chooses not to do so, but the seller, me, in this scenario, decides I want to back out of the deal. Can the buyer take me to court and force me to go through with it? Yes, he can. It's still a valid and enforceable contract. But if he decides he wants to void it out, he can do that. Earnest money is a buyer's good faith money that they put down on a contract to ensure the seller that they're serious about going through with the transaction, and to possibly prevent them from backing out of the deal because they risk losing their earnest money should they do so. But earnest money is not required by law. There's nothing in the law that says you have to have it, but the majority of contracts will include earnest money. Earnest money is normally held in the broker's escrow account. Now, there's nothing in the law that says a broker has to maintain an escrow account, but if they accept an earnest money deposit, they're going to have one. So most larger brokerage companies will maintain escrow accounts. Some of the smaller ones don't. And there is a lot of record keeping that is involved with escrow, and a lot of rules that have to be adhered to, because when the broker is accepting that earnest money deposit, he's holding on to other people's money. So that's the buyer's good faith money, and it's going to be held in that escrow account and then credited back to the buyer at the closing. So this escrow account is going to be non-interest bearing, and the broker can have all different agents putting money into that one, depositing money into that one escrow account. So if the broker maintains that escrow account, he absolutely cannot release that earnest money unless they have the signatures of both parties. For example, if the buyer and the seller come to a disagreement and maybe the buyer is going to back out of the deal and wants his earnest money back, the broker cannot release the earnest money until they get the signatures of both the buyer and the seller on the release form. So the broker has to continue to hold earnest money for 5 years if it's not been distributed. And if nobody is looking for the earnest money, after 5 years, the broker will turn it over to the state as unclaimed funds. Believe it or not, that does happen. People kind of disappear and forget about it. But if one of the parties wants the earnest money back, there's a 6-month rule that was written into the law that states 6 months after the request of one of the parties for the release of earnest money, the broker may turn that money over to the state at that point as unclaimed funds. So, for example, buyer wants his earnest money back, seller's mad, won't sign the release. 6 months after they get the request from the buyer, they can turn it over to the state. Now, if there is money on the books with the brokerage company and maybe somebody's fighting, or maybe it's just sitting there and everybody's disappeared and they just want to get it off of their books, they can file an interpleader action with the court and turn that money over to the court, and the court decides on how to dispose of it. So, as I said, there are careful records that have to be kept if a broker is going to maintain an escrow account. They have to have a journal for each escrow account, which is an accounting of all the money coming in and out of that account, because at the closing, they're going to take that money and credit it back to the buyer at the closing. There has to be a ledger for each transaction. Each escrow account has to have a monthly reconciliation statement. So if the bank a broker is going to use for their escrow account only issues weekly or quarterly statements, you can't use that bank. Has to be a bank with a monthly bank statement, and it has to be reconciled within 10 days after receipt each month. The master escrow account log is the document submitted to the IDFPR because they want to know where a broker is maintaining escrow accounts. So escrow records have to be kept for 5 years. The immediate 2 years have to be on site, and the other older records can be at an off-site storage facility or warehouse. If the IDFPR wants to come in and investigate those records, they have to give 24 hours notice to look at the records that are up to 2 years old and on site, and they have to give 30 days notice for records that are a little bit older, up to 5 years old. 2 terms that would be good to know: commingling and conversion. Commingling means mixing the money between the bank accounts. For example, if a broker has an escrow account, which again, he's holding on to other people's money with, and he's got an account that he operates the general business fund out of, and he gets a little short in that, so he's going to move a little money around from the escrow account. That's commingling. That'll get him in big trouble quick. Conversion is when the broker actually withdraws money out of an escrow account and uses it for their personal use. Regarding earnest money, there is normally going to be a liquidated damages clause in the sales contract, which states that in the event the buyer defaults on the contract, that the seller is entitled to retain the earnest money. Oftentimes that will also state that that will be the seller's sole remedy, and if it does, the seller agrees not to go after the buyer for further damages. Either way though, even if there is that liquidated damages clause, before the broker can release the earnest money, they have to get the signatures of both of the parties. Next, we will talk about transfer of title. And title is kind of an intangible. You can't see title. The way someone receives title to property is via a written document, and that written document is called the deed. So there are different types of deeds that we will talk about here in a minute. But first thing to remember, in a deed, you have a grantor, that is the person that is giving the deed. You have the grantee, the person that is receiving the deed. The grantor signs the deed. The grantee does not sign the deed. Important to remember that title is said to pass when the deed is delivered and accepted by the grantee. So Also in a deed, you have to have granting clauses, consideration, and in a deed, consideration is not going to be the actual sales price. It's going to be, deeds are going to state $10 and other valuable consideration, or if it's a gift, it'll say love and affection. But deeds are not going to state the actual value or sales price. You have to have a legal description in the deed. We talked about legal descriptions a few moments ago. In a sales contract or on a listing agreement, the street address is fine. Legal description is permitted, but street address is fine. However, in a deed, the legal description must be indicated on there as well. So, deeds by law do not have to be acknowledged or notarized. Most of them are, however. Deeds also by law do not have to be recorded. Again, most of them are. Because by recording a deed, it protects the grantee's interest. Before, even though I said deeds do not have to be acknowledged, although most of them are, before a deed can be recorded, it will not be able to be recorded unless it's acknowledged. So at the end of the day, most deeds are acknowledged and recorded. So when you're looking at your different types of deeds, I would recommend writing all the different types of deeds on a piece of paper so that you can memorize them, and kind of indicating underneath each one what is included in that deed. So I'm going to run through them for you right now. So in a general warranty deed, or if you just see warranty deed, it's the same as general warranty deed. First of all, the granting clause in that is going to be convey and warrant. So it's a good idea to know your granting clauses in these deeds. The general warranty deed offers the best protection of any deed. If a buyer gets a general warranty deed, that means the grantor is guaranteeing the title to that property, not only during the time they owned the property, but also prior to their ownership, all the way back to its origins. So he not only guarantees the title during the time he owned it, but back to its origins. The general warranty deed also has the most complete warranties included in that deed. So that is the best protection of any deed. The next one is a special warranty deed, and the granting clause in a special warranty deed is remise, release, alienate, and convey. If I give you a special warranty deed, I'm only giving you two warranties. One, I do own the property and I have the right to convey it to you. And two, I did not encumber it while I owned it, but I can't guarantee anything prior to my ownership because maybe I don't know what happened to it, what the status of the title was prior to my ownership. Maybe I got the property at a tax deed. I didn't get a general warranty deed. I can't guarantee it any further than the time I owned it. You have a bargain and sale deed, and the granting clause on that is grant, bargain, and sell. This is very seldom used in Illinois. In a bargain and sale deed, it's just less complete in its warranties than a general warranty deed, and it just implies that you have title and possession. So seldom used. A quitclaim deed, the granting clause is remise, release, and quitclaim. Quitclaim deed is the least protection of any deed. In a quitclaim deed, the grantor is giving the grantee any interest they have if they have any, but there are no guarantees or warranties. Stupid example, but I can give you, I'm going to sell you all the interest I have in the Golden Gate Bridge for $1 million. Okay, great. You're going to pay me $1 million and I'm going to give you all the interest I have in it. Perfectly legal. This is how much interest I have, 0. That's all you're getting. No guarantees, no warranties. But if I have a substantial interest, that's what you're getting too. So it will convey whatever interest I have. The time that you will see the quitclaim deed more commonly is in a divorce situation where one spouse will quitclaim their interest over to the other spouse. So again, whatever interest I have, but no guarantees, no warranties. A deed in trust puts property into a trust, and a trustee's deed takes property out of a trust. One other point, in a deed executed pursuant to a court order, as I said before, only nominal consideration is stated in a deed except this one. In a deed executed pursuant to a court order, the actual sales price is going to be listed in the deed. Move on to involuntary alienation. That's the involuntary transfer of real estate. Adverse possession is also sometimes referred to as squatter's rights. So if someone moves on to someone else's property and they live there for a period of 20 years in Illinois, every state has different time frames, but in Illinois it is 20 years. Live there for 20 years, they can actually take title away from the person that owns the property. So if you have property somewhere and you don't pay any attention to, and you go and find that somebody has moved onto your property, maybe they've moved a mobile home on there or whatnot, after 20 years they can actually take the title away from you. So another thing to remember, you can never take government land by adverse possession. Adverse possession is only for privately owned property. So you could not go into the forest preserves, for example, and expect to take that land from the government. If a person dies testate, that means they died with a will. If a person dies intestate, that means they died without a will. So if someone dies intestate without a will, what's going to happen is the state's essentially going to make a will for them. So they will look toward the Illinois Descent and Distribution, and the state will make the will for the deceased person. So important again to have a will. So in order to make a will, a valid will in Illinois, you have to be 18 years of age. It has to be witnessed by 2 people, and neither one of those witnesses can be a beneficiary of the will because that will void their gift. And it has to be signed by the testator. So the process of probate, what that does is that proves or confirms the validity of a will. Now, talk for a minute about transfer tax stamps. So transfer tax stamps are imposed on homeowners that sell their property in Illinois, and these transfer tax stamps are paid by the seller. So for each $500 of sale price or fraction thereof, in Illinois, the seller is required to pay 75 cents in transfer tax stamps. That 75 cents breaks down as such. 50 cents of that 75 cents goes to the state, and 25 cents goes to the county. So for example, if you have a property that is selling for $100,000 here, for each $100,000 of sale price, for each $500 of sale price, the seller will be required to pay 75 cents total. So what we have to do first then is find out how many increments of 500 are in this $100,000 sale price. So what do we have to do? Divide it by 500. That'll give us 200 increments times the 75 cents. 150 bucks is what the seller would be required to pay. Now, the way it reads is for each $500 of sale price or fraction thereof. So what that means is if the property sells for even a penny over $100,000, let's say it sells for $100,100, you're going to have to pay the entire 75 cents on that next 100. So probably the easiest way to do this is round it up to the next $500, because when you divide it, you have to have an even number here. So round it up, so that would be 201 increments times your 75 cents. They'd have to be paying another 75 cents, 150.75. If there are personal property items included on the sale, that is deducted. The seller does not have to pay transfer tax on the personal property items. And if the buyer is assuming the seller's existing loan, or it might word it, take it subject to the seller's existing loan, it means the same thing. The buyer's taking over the seller's loan. The seller is not required to pay transfer tax on the amount that the buyer is assuming or taking subject to. So that would be subtracted out as well. One thing to remember is if you see a question regarding transfer taxes, if they ask you for state transfer taxes, it's 50 cents. If they ask you for county transfer taxes, it's 25 cents instead of the 75. But if they just ask you for total transfer tax, $75 cents for each $500 or fraction thereof. Talk a little bit about title records. We talked about deeds a minute ago, and again, the deed is the written document that transfers the title. Important to remember that a deed is never evidence of ownership. Anybody can go to Staples and buy a stack of deeds and forge them and give them to someone. It's not proof that somebody owns the property. So your three forms of evidence of title in Illinois, important to remember, is your certificate of title, your abstract with an attorney's opinion, and your title insurance. Now the first two, the certificate of title and abstract, and those are used sometimes in Illinois, but they're not the best defense of title because there are no guarantees or warranties involved with that. But your best defense of title is your title insurance. Title insurance is the best defense of title in Illinois. So those are your three forms of evidence of title. Best one is title insurance, and remember that a deed is never evidence of title. We'll talk a little bit about some Illinois licensing items. When you take your state exam, remember it's divided into two sections. You're going to have 100 questions that are going to deal with national items, which is most of everything we've covered here pretty much today, and we'll continue to cover. And then you're going to have 40 questions on Illinois specific law. So I'm going to run over a few points on that as well. Advertising in Illinois, any advertising that a licensee does has to be done in the name of their sponsoring broker. Sponsoring broker's name has to be in all ads, and the sponsoring broker's name has to be at least equal in size or larger than the licensee's name or the team name. If the sponsoring broker's name is not included in the advertisement, it is a blind ad, which is illegal. If a licensee is selling their own personal property, the state says you can do it in one of three ways. You can sell your own personal property by owner as long as your sponsoring broker approves. You can sell it using the services of your sponsoring broker that you work for, which makes the most sense if you're selling your property in the area where you work. Or you can use the services of a brokerage company that is not your sponsoring broker. That would apply most likely if you're selling your home in a different part of Illinois where your brokerage company doesn't service. But if you are selling your property, your personal property by owner, you have to put agent owned on the sign and in any ads. Regardless of how you're selling your property, you must make sure that it is disclosed that you have a real estate license. As far as receiving your compensation, you're only going to receive your compensation from your sponsoring broker. There is one exception to that. If you are working for brokerage company A, for example, and you have earned a commission while you were working there, and you have moved on to brokerage company B, and you still have that deal with brokerage A and they've agreed to pay it to you. You're now working for brokerage B because you earned that money while you were with brokerage company A, they can pay you directly. That's the one exception. Other than that, you only receive your compensation from your sponsoring broker. If you receive any compensation at all in the transaction from a third party, that has to be disclosed as well. If you refer your client to use the services of a service provider and you own part of that company that you're referring your client to use, under Illinois law, if you own greater than 1%, you have to disclose it. However, under RESPA laws and under the Code of Ethics, if you have any interest in a company that you are referring your client to use, you have to disclose it. Illinois law, 1% across the board, any interest. It is illegal to compensate anyone in violation of the act. So if there is somebody that has a suspended license, you cannot pay the co-op commission to somebody with a suspended license. Or somebody that is has an expired license at the time. You cannot pay them, otherwise you'll be in violation. You cannot pay a referral fee to an unlicensed person. For example, if your friend gives you her grandmother's house to sell and you're grateful to your friend and you'd like to give her $100, it's illegal. She doesn't have a license. Remember that compensation is anything of value. You can't even give her a gift card, or you can't give her, tickets to the ball game, any of that. None of that because she gave you a referral. Other reasons you could give it to her, but not because she gave you a referral. Now, as we said, you cannot pay anyone that does not have a license, But what you are allowed to do is you are allowed to offer some form of compensation, gifts, prizes, money compensation to someone to try to garner business. For example, you have a listing and you're really anxious to get a buyer for it. You can offer a big screen TV to somebody that comes under contract on your listing by June 30th. Once they're under contract, they've become your client. Now you can share something with them. Additionally, you can share compensation with the principal, with your principal in the transaction or your client. One example, you're at the closing and you're grateful that it closed very quickly, and maybe the client was a family member and you'd like to give some of your commission back to them. That's perfectly legal to do. But what you need to remember is you can't give everything back to them because it's not all yours. Some of it goes to your sponsoring broker. What is allowed under the law? As we said, you can only receive your compensation from your sponsoring broker, but what is allowed is for an agent, a licensee, to set up a company, a business entity. The business entity that is being set up would not be for doing business. This agent is still going to do business under their sponsoring broker, under their name, under their sponsoring broker. But the purpose for this business entity is just to receive compensation. So what that means is instead of the sponsoring broker paying the agent directly, they pay their company. And so this company that is set up either has to be solely owned by the agent, or the agent's spouse can be owner of that company as well, as long as the spouse is either not licensed at all, or if the spouse is licensed, they're licensed under the same brokerage company. So this company that is set up can receive compensation not only from the real estate business, but also from any other businesses that this agent might have, like a lawn cutting business or a dog grooming business or whatever they have. All the money goes into the company and then they pay themselves out of the company. There are various items that you can be disciplined for in Illinois. And if you violate any of the license law items, like if you act as an undisclosed dual agent, or you do something illegal with escrow money, you're commingling or conversion with escrow money, or you are a broker and you release earnest money without signatures, violate your fiduciary duties to your client, you're an undisclosed dual agent, the list goes on and on. You can be disciplined for any of that by the IDFPR. And if you are disciplined and you go before a hearing and they find you guilty, they can suspend your license, they can revoke your license, they can fine you. So you want to make sure that you do not violate the license law. Now, there are 4 things that the state, the IDFPR will catch really pretty quickly, and you'll be subject to discipline. 1, if you fail to file your Illinois state tax return or fail to pay your Illinois state taxes, they don't care about your federal, your Illinois, they'll suspend your license. If you are more than 30 days in arrears on your child support payments, your license will be suspended. If you default on a student loan issued in the state of Illinois, they will suspend your license. So in all of these 3 instances, your license will be suspended. They won't fine you because they want you to get that paid up so that you can have your license reinstated. The other thing that they will catch you on is if you say you did your continuing education every 2 years and you don't do it. So when you go to renew your license, you'll have to check the box that says I've completed my continuing education. Otherwise, they won't let you renew it. And if you have not done that and you lie about that, they will get you. It might be a few months, but they will get you. They no longer discipline you for that. They will give you it's like a ticket, it's a citation, so like a traffic ticket. So you will have to pay it, and it's not cheap. It's anywhere between $1,500 and $2,500, and then you'll have to do your CE. So you will not be disciplined for that unless you have 2 or more citations and pay 2 or more fines. One important thing to remember, if a licensee is found guilty of discrimination, the IDFPR has no choice. The license will be suspended or revoked. In the event that a consumer is harmed or a member of the public is harmed by a licensee's actions, and they take them to court and they're issued a judgment because of the fault of the licensee, The aggrieved party has to go after the licensee first and get whatever they can from them. And when there's not enough to satisfy the judgment, they can go to what is called the recovery fund, which is maintained by the IDFPR, and state their case. The recovery fund board will look at it, and if they decide it's warranted, they will pay out on behalf of that licensee. Now, if that happens, the licensee has to surrender their license, and so they can't work. Now, the licensee can get it back, but they have to pay the recovery fund back all the money that was paid on their behalf, plus interest. And then it goes before the board to decide whether or not to give it back. Filing bankruptcy does not discharge this judgment. It's not going to get the licensee out of it. So, and again, while that is going on, the license has to be surrendered, so that licensee cannot work. There are a couple of chapters in your book, in your pre-license book, that deal with finance. And the finance chapters are not specifically math. There's a little bit in there, but the finance chapters is a lot of theory and a lot of definitions. So my best advice on those chapters on finance is to go through those definitions. There are a ton of them on there. But I'm going to go through some things right now to make sure you understand. A lot of people get confused because people, when they go to buy a house, what does everybody say? I'm getting a mortgage. Actually, that's incorrect. When someone goes to get a loan for a property, they're not getting a mortgage. They're actually giving a mortgage to the lender. So when someone gets a loan, they're going to give two things to the lender. They're going to give the lender the note, which is the promissory note that says, I promise to pay you back this much money in this many installments over this period of time. They're also going to give the lender the mortgage, because what the mortgage is it's a security instrument that allows the lender to put a lien on the property. So that's what the borrower, who is the mortgagor, gives to the lender, who is the mortgagee. In return, they get the money. Okay, so that's a little bit confusing in everyday terms. A loan origination fee, that is the way that the lender gets paid for taking your loan application. A loan origination fee is paid by the borrower, and it is always a percentage of the loan amount. It could be 1%, 1.5%, 2%, whatever the lender wants to charge. That is how they get paid. If the lender charges a higher rate of interest, there may be no discount points involved in it. But if the lender is going to offer a lower rate of interest, which would lower the borrower's monthly payments, the lender is going to want to get their money out of it too, so they're going to charge points. Points are prepaid interest. So you could get a lower interest rate and pay points up front, or you can take the higher interest rate and pay more throughout the life of the loan. A point is always 1% of the loan amount, always. Now, points are a matter of negotiation between the buyer and the seller in the contract. In other words, the buyer can ask the seller to pay all or some of their points. And depending on how the bottom line works out, sometimes, that will make the deal work. So points can be negotiated between the buyer and the seller in conventional loans, VA loans, and FHA loans. So some states use what is called a deed of trust instead of a mortgage. In a mortgage, as we said, you've got two parties. You've got the borrower, who's the mortgagor, and the lender, who's the mortgagee. Again, the borrower gives the lender the note and the mortgage. Lender gives them the money. When the borrower pays all the money back, the lender is required to issue a satisfaction of mortgage back to the borrower, releasing all the rights back to the borrower. Some states will use a three-party system called a deed of trust. And some of the terminology that we'll use here is a little bit confusing because we've used it before when talking about trust. But in a deed of trust situation, the borrower is called the trustor. The lender is called the beneficiary. And there's a third party called the trustee. So what happens is the borrower gives the note, the promissory note, to the lender, who is the beneficiary, and they give them the money. The third party, the trustee, obtains a deed of trust from the borrower, who is the trustor. So the trustee in this situation has what they call bare legal title or naked title. That is title without the right of possession. So the important thing to remember in a deed of trust situation is that the trustee has the power of sale clause. So what that means is in the event the borrower defaults on the mortgage, the trustee has the power to sell the property and return the money back to the lender. So in states that use deeds of trust, they really don't have a foreclosure process, because if the borrower defaults, trustee sells the property, goes back to the lender. So difference between the mortgage and the deed of trust, one has two parties, one has three. Okay, going through some of these terms, the acceleration clause, if someone misses their mortgage payment, the lender can accelerate the remaining payments due and payable immediately. In other words, they can call in the loan. That's because of the acceleration clause in a mortgage. Alienation clause is also referred to as a due on sale clause, a resale clause, or a call clause. Basically what this means is that if a property is sold or transfers title, the loan has to be paid off. What it does is it prevents somebody from assuming a loan at lower interest rates that might have been gotten 20 years ago, right? So one thing to remember though is that you will never see alienation clause or due on sale clause in an FHA or a VA loan. The reason being that FHA and VA loans are assumable loans, and an alienation clause will prevent the assumption of a loan. Okay. Talk a little bit about land contracts. So, give you the example. If I'm selling you my property and maybe you would like to buy it, but at this point financing is unobtainable for you. So we might enter into a land contract. So what will happen is I will pretty much act as the bank. So you're going to move in like you own it. You're going to take care of the repair, maintenance, upkeep, in most cases taxes, insurance, everything. But you're going to make payments to me. I'm going to hold on to the title until you've paid me the last dime. Up until that point, you have what we call equitable title, which means you have a future interest in the property. You don't have title yet, but you're getting it at some point in the future. Once you've paid me, legal title gets transferred onto you. We talked a little bit about taking property subject to or assuming someone's mortgage. There's a distinction here. If a buyer takes a property subject to, the buyer is taking over the seller's loan with the intention of making all of the payments. The problem is, if the buyer defaults on this loan and it gets foreclosed on by the lender, the buyer on this is not going to be liable. The original seller will still be liable. The difference between that and an assumption is the buyer takes over the seller's loan, and at some point the seller can be relieved of that loan. So in other words, what will happen in an assumption is the buyer will take over the loan and the lender will watch it for maybe a year or two to make sure that the buyer is establishing a consistent payment history. And once they're sure of that, they'll release the seller. So the seller will still be liable in an assumption until they're released by the lender. But if the seller wants to get completely out of it and not be liable for anything, they would execute a novation agreement where a novation is a substitution. So they would substitute the new buyer on that loan and relieve the seller. There are different types of foreclosure proceedings. You have the non-judicial foreclosure, and that is a situation where you have states that use deeds of trust and they have that power of sale clause. So in that case, no court action is required. You have the judicial process, and Illinois is a judicial foreclosure state, which means you have to go through the court process to foreclose on a property with proper notices being given. You have strict foreclosure. Some states have this where actually no sale takes place. In the event of a default, full legal title just gets returned to the lender. You have a deed in lieu of foreclosure, referred to as a friendly foreclosure. In a deed in lieu, basically the homeowner or the borrower just turns the keys over to the lender and says, I'm walking away. However, in a deed in lieu of foreclosure, the lender has to agree to it, because in a deed in lieu, the lender has to take the property subject to all junior liens. In a foreclosure sale, those junior liens are going to be eliminated. We have the Federal Reserve System, and the Federal Reserve System is going to maintain sound credit conditions, help counteract inflationary and deflationary trends, and create favorable economic conditions. You have the primary mortgage market. The primary mortgage market is where loans are originated, where you actually sit down and do your loan application. Then we have the secondary mortgage market, and the secondary mortgage market is the market where loans are bought and sold after they have been initiated in the primary market. And the reason that primary market members will sell those loans in the secondary market is to free up working capital so that they can make more loans. Now, your three players in the secondary market that would be important to remember are Fannie Mae, Ginnie Mae, and Freddie Mac. Fannie Mae deals primarily with conventional VA and FHA loans, all three of them. Ginnie Mae deals with special assistance loans, specifically FHA and VA loans, and Freddie Mac deals with conventional loans. So in order to be a qualified mortgage, in other words, in order for a mortgage to be sold on the secondary market, it has to meet certain income and credit qualifications. And if the borrower's income and credit qualifications are outside of those limits to be sold on the secondary market, it doesn't mean that they won't get a loan. But because it won't be able to be sold in the secondary market, the lender would look to their investment portfolio and have one of their underwriters there maybe undertake that loan, one of their investors undertake that loan. Because it would be an unusual type loan, the interest rates are going to be a little bit higher because it will be considered a riskier type of a loan. You have a straight loan, which is an interest-only loan. In a straight loan, you're only paying interest. It's also referred to as a term loan or an interest-only loan. And at the end of the loan term, the entire principal is still due. That's not a very popular loan item. An amortized loan is the most common one. In an amortized loan, you're paying principal and interest each month and the same amount each month over the course of the loan. When you've made your last payment on the loan is paid off. The difference here is the amount of money that is paid toward principal and interest with each payment. So the first few years of your mortgage payment in an amortized loan, you're paying almost all interest and very little principal. With each payment that is made, the amount that is allocated to interest declines and the amount that is allocated to the principal increases. So by the time you get to the end of the loan, you're paying almost all principal. The beginning of the loan, you're paying mostly interest, end of the loan, almost all principal. You have an adjustable rate mortgage loan, which is a riskier type loan. You start out at a lower rate of interest than the going rate, and then that interest rate will adjust. Normally it'll be annually, it could be weekly or monthly, but normally on your loans it'll be an annual adjustment. It'll be based on the Treasury securities, most likely, but the interest rate could adjust on a certain date each year. So if the economic indicator goes up, your interest rate's going up. If it goes down, your interest rate goes down, which means your payment goes up or down. So why I say riskier type loan is you start at that lower rate, but then it could keep going up on you. You have a balloon loan, and a balloon loan is a partially amortized loan. In a balloon loan, you are paying principal and interest for a set period of time, maybe 5 years, maybe 7 years. You're getting a little bit lower interest rate than the going market rate. But at the end of that 5 or 7 year period, if it's a 5-year balloon, it'll be the 5-year period, the entire principal is due. So again, riskier type loan because many people feel, well, I'll just refinance it when I get to the 5 years. Well, maybe the interest rates have gone way up at that point, or maybe you've lost your job or your credit's tanked and you're unable to refinance it. So it is a riskier type loan. Reverse mortgages are available to those 62 years of age or older. I always think of it as spending your kid's retirement. If someone over the age of 62 has equity built up in their home, they're able to draw from that money without having to pay it back. The problem is it goes as a lien against the property and the interest accumulates. When that homeowner either dies or they move, that loan has to be paid off. We have a package loan that includes real and personal property included in the loan, a blanket loan. This is a loan that a developer will get on a subdivision, for example, and they will have what is called a partial release clause in this blanket loan. What that means is as the developer would sell off a particular lot, they're able to release that lot from the lien and from that loan, and the loan will still apply to all the other lots in the subdivision. You have an open-end loan that's like a line of credit. You have a buy down that allows you to buy down the interest rate for the first 1 to 2 years of the loan, and a construction loan. So let's say that you are going to get a construction loan because you are going to build a home. And so what will happen is you'll get that amount of money sitting there and you'll make draws on it. So as the guy does the foundation, you make a draw off of that and pay that guy. And the guy does the plumbing, you make a draw. And you're only going to be charged interest on the money that you have taken out. At the end of that loan, you have to have arranged for a takeout loan to take out that original construction loan. And that takeout loan would then be your new mortgage. In an appurtenant easement, you have 2 adjacent parcels of land. So let's say, for example, there is a lake right here. And this lot owner, this is lot A and this is lot B. And at some point in time, lot A and lot B decided that whoever owned it decided they would create an appurtenant easement for whoever owns this property to get over here to the lake. Okay? This is an appurtenant easement. In order to have an appurtenant easement, you need 2 adjacent parcels of property. The property that is being used is the servient tenement, and the property that is benefiting from the use of the easement is the dominant tenement. Now, it's important to remember that this runs with the land. So if whoever owns A sells it to somebody else, there's a disclosure that whoever owns this property has the right to get to the lake to use this parcel of land. It's also a disclosure issue for the dominant tenement, just to disclose that whoever buys this has the right to use this property to get to the lake. Now, should the servient tenement decide he no longer wants this easement over his property, he can't do anything about it. However, the dominant tenement can remove the easement, but it's unlikely that they will do so because it's going to be a plus for that property. It would add value to the property to have access to the lake. So the servient tenement can't remove it, but the dominant tenement can. However, if the servient tenement, one of these parties, buys both properties, owns both properties, and they merge the 2 lots together, the easement will go away because you cannot be the holder of an easement on your own property. Now, an easement in gross. This can be a commercial easement in gross or a personal easement in gross. The best example that I can give you of a commercial easement in gross would be the utility company, because they have the right to come on your property to dig up wires or whatever they need to do. That belongs to the company. They have that commercial easement in gross. But it can also be a personal easement in gross. A personal easement in gross is when someone is given the right to use the property of someone else's in either a deed or a will. So if I have a lake on my property and I'm going to give you in a deed or in my will the right to use my property, you have the right to use it. I can't change my mind. You have the right. It will terminate upon your death. It runs with the person, with you, not with the property. This is different from a license. A license is just permission. So if I give you permission to use my property, I can change my mind at any time. You don't have the right to use it. So look for that in a question. If someone has been given the right to use someone else's property in writing, in a deed or a will, they have the right to use it. Also have an easement by necessity. What an easement by necessity means is that you cannot be landlocked. So if I have a lot and maybe I sell off the back end of my lot and the only access to the street or roadway would be going over part of my land. When we consummate that sale, we would have to create an easement so that you have access to the roads. If we don't do that, the courts will do it because you cannot be landlocked. So an easement by necessity prevents someone from being landlocked. Next is an easement by prescription. If someone uses someone else's property continuously and uninterrupted for a period of 20 years in Illinois, they have gained an easement by prescription. So, it's kind of a silly example, but let's say that I walk across the street, walk across my neighbor's lot every morning to get a cup of coffee at the little grocery store. Every morning I do it, I don't miss a beat, right? After 20 years plus, my neighbor says, I'm putting up a fence because I don't want you walking across my yard anymore. Can't do it. I can go and have that blocked because I have been doing this continuously and uninterrupted for a period of 20 years. I now have the right because I have an easement by prescription. Now, an encroachment is when somebody builds a portion of a building or a structure over onto someone else's land. So let's say that my neighbor has built their fence 2 feet onto my property. That's an encroachment. If we don't do anything about that and that fence is there for 20 years, they will have gained the right to keep that fence there because after 20 years, they would have that prescriptive easement. So the fence will be staying. I always ask the students, those of you that own homes, do you have any idea how you hold title to property? And most people have no idea. If you own your home all by yourself, you're a severalty owner. No other way it can happen. If a property is owned by 2 or more people, you can be tenants in common, you can be joint tenants, or you can be tenants by the entirety if you are married. So the first one we'll talk about is tenants in common. Right here. Let's say that we have 3 people, A, B, and C, and they're going to purchase a property. Maybe A is going to put half the money in, and he's going to own half of it. B is a fourth, C is a fourth, or 25%. They're tenants in common. What's divided up is not the property itself, but their ownership interest. So, because of that, A owns a half, and let's say A would like to sell his half. He can do that. He can't sell the whole property, but he can sell his interest to someone else. He could sell it to D. Now D will own a half, with B and C each still owning 1/4. If C dies, C can will his interest to E. Now E would own the property with A and B. So they're tenants in common, and property in a tenancy in common will go through probate. So it's your ownership interests that are divided up, not the property itself. Now, one might choose to own their property as joint tenants. So let's say A, B, and C are going to choose to be joint tenants. The most important thing to remember about joint tenancy is that you have the right of survivorship. So if one of the joint tenants dies, the others automatically get their share. It doesn't matter if they have a will or if they're married, because again, the way you hold title to real estate will supersede any will or any heirs. So let's say A dies. If A dies, B and C own it as joint tenants. Let's say then B dies, C will own it in severalty. Now here is something that is allowed. It is allowed for someone who is a joint tenant to sever the joint tenancy and make themselves a tenant in common in order to sell or will their portion. So right now, as a joint tenant, if one of them dies, their portion's automatically going to go to the others that are left. And you cannot sell your portion or will your portion while you're a joint tenant. But what is allowed is for one of the parties to sever the joint tenancy. So A decides he doesn't want to be a tenant in common any longer with B and C. A can sever the joint tenancy and make himself a tenant in common. And because there were 3 of them, he would then own a third. So now what we have A as a tenant in common owning 1/3 of this property. Again, the property itself is not divided, the ownership interest. And B and C, they're going to remain joint tenants owning 2/3. So now, B and C are still joint tenants. They cannot will their share, nor can they sell their share. But A is a tenant in common. So A can sell his share, or he can will it to somebody else. Now, since B and C are still joint tenants, you still have the right of survivorship. So if B dies, C will own it, 2/3 interest. C can no longer be a joint tenant because there's only one. And C is not a severalty owner because C doesn't own the whole thing. So the only thing, if B dies, now C would be a tenant in common owning 2/3, and A would be a tenant in common owning 1/3. Now, either one of these, A or C, either one can sell or will their interest. Now the next one is tenancy by the entirety. You have to be married in order to be tenants by the entirety. So let's say we have a husband and a wife here. So you also have the right of survivorship. So if one of them dies, the other one automatically becomes a severalty owner. The reason that married couples hold title as tenants by the entirety is that if there is a lawsuit against one of the spouses, they can't take the house. If they get divorced, they can no longer be tenants by the entirety. So in the event of a divorce, they would automatically become tenants in common, each owning one half. So one example to help you understand it, let's say you have a married couple, and maybe the married couple had children from their previous marriages. This is their second marriage for them, and they purchase a house together. And they want to take title in such a way that if anything happens to either one of them, that it wouldn't go to the other spouse, that it would go to their children via their will. Well, if that's the case, how would they have to hold title? They'd have to be tenants in common, because tenants in common is the only way that you can hold title where you can will your interest. Joint tenancy or tenancy by the entirety, you have the right of survivorship. So if one of the parties dies, the other party will automatically get it, and they can't will it to anyone else. Okay, so talk a minute about trust. So oftentimes people will put property into a trust, and I'll give you an example here. Let's say a grandfather has an oil well, and he is going to give the property to his daughter to manage for the benefit of his granddaughter. So grandpa is the trustor. He's going to give the property to his daughter, who is the trustee. Now, she is the title holder of record. The trustee owns the property, but she owns it without having full control over the property, because she has to manage it per the instructions of the trust. And in this scenario, she's managing it for the benefit of her granddaughter, who is the beneficiary. You can also have a land trust. And in a land trust, the trustor is also going to be the beneficiary. So a person could purchase a property, put it in a trust, and normally that'll be the trust department at a bank, and they will remain anonymous. The title holder of record will show up as the trust department at the bank. So they're the trustor, put the property in a trust, but they're also reaping the benefits from the property. They're also the beneficiary. So oftentimes investors will do this if they want to remain anonymous. If they're investing in numerous parcels of land and they don't want people to know it, they'll put the property into a trust. Also, property in a trust does not go through probate. So there's a difference between condominiums and co-ops. In a condominium, you own your unit. You're responsible for the taxes on your unit, you're responsible for your mortgage payment, as well as a monthly fee that is paid to the association. And the association will collect that fee to take care of the common areas of the building and the yard work and the maintenance, etc., insurance on the building. But you are responsible for your unit, and you will own your unit in one of the three ways, or one of the four ways we discussed. If you're by yourself, you'll be a severalty owner. If you two or more people can be joint tenants, tenants in common, or if married, tenants by the entirety. In a condominium, not only do you own your unit, but you also are going to own a percentage of the common elements in the building along with the other unit owners. So common elements would be the basement area, the yard, the parking lot, the lobby area. So let's say that there are 8 units in the building. As a unit owner, you would own 1/8 of those common elements with the other unit owners. And the way you hold title to the common elements is as a tenant in common. Now, when you sell or transfer your condominium, your percentage of the common elements has to go along with that. It cannot be sold or transferred separately. Another term to know is a limited common element. And a limited common element is a common element that pertains to one particular unit. For example, in the parking lot, that is a part of the common elements, correct? But maybe there's a parking space for each particular unit. Those would be limited common elements. Now, in a co-op, a little bit different. You don't actually own real estate in a co-op. In a co-op, you own shares of stock. And by purchasing those shares of stock, that enables you to occupy one of the units. And so a company will own the land and the buildings. You purchase shares of stock, it gives you a right of occupancy, and that right of occupancy is called a proprietary lease. It is not your standard lease agreement. A proprietary lease, by definition, is a right of occupancy. So by purchasing shares of stock in the corporation that owns the land and the buildings, you get the right to occupy one of the units. So you don't have a mortgage on that, but you do have to pay a fee to the company for your maintenance, for your portion of the taxes, insurance, etc. So in a co-op, you are able to list and sell co-ops on the MLS without having a securities license under the Illinois license law. So it is a separate category, so you will be able to do that as well. Next, we'll talk about legal descriptions. So the metes and bounds legal description is the oldest type of legal description. With the metes and bounds legal description, you use compass points and directions to encircle a tract of land. So you would start at one point, which is called the point of beginning, and you would use directions to encircle the tract of land being described and end up back at the point of beginning. You also have the lot and block system, which is used to describe properties in subdivisions, and the rectangular survey system. The rectangular survey system uses two primary survey lines. The principal meridians run north and south, and the baselines run east and west. Parallel to the principal meridians, you have additional survey lines called range lines. So parallel to the principal meridians, you have range lines that go north and south, and they're located every 6 miles apart. Parallel to the baselines, you have township lines that run 6 miles apart. So where these intersecting range lines and township lines intersect, they form squares, and these squares are called townships. So this township here is formed by your intersecting range lines and township lines, which are 6 miles apart, which means that each township is 6 miles by 6 miles. Each township is further divided into sections. There are 36 sections in a township. The numbering starts in the northeast corner, and it winds around like this and ends up in the southeast corner. So each township is 1 mile by 1 mile. So the important thing to remember is that the township is bigger than the section, right? A township is 6 miles by 6 miles, and a section is 1 mile by 1 mile. So there are 640 acres in each one of these townships. Now, in real life, you will not be asked to figure any of this out, but you may see a question or two on the state test, so that's why we're going to cover it. Now, in a legal description, you might get a question asking you how many acres are in a particular legal description. So when you get a legal description, this is only a portion of the legal description. A legal description will also reference the range line, the township line, the principal meridian, or the baseline. But for the purposes of what we're doing here, you don't need all that. So to simplify it, you might get a question stating this type of a legal description and asked how many acres is in that legal description. So you're always going to work backwards through the legal description. And we said earlier that there are 640 acres in each section, right? So in section 14, we have 640 acres. So we're gonna go backwards. And we go backwards in the legal description, and when you hit the word of, you're going to divide, as you see here. And keep going backwards, you hit the southwest 1/4, so you're going to divide by 4. So far, you're at 160 acres in this parcel of land, but you're not done yet. You need to keep going backwards, and you hit the word of, so you divide again, and you hit the northwest 1/4, so you're gonna divide by 4. Now you're at 40 acres. And you keep going backwards, and you hit the word of again, and then you hit the north 1/2, so you divide by 2, 20 acres. So in this legal description right here, you have 20 acres. Now, one other thing to tell you about is down here, you might see the word and in a legal description. If you see the word and in a legal description, it means you are describing two separate parcels of land, and you need to stop and start over with another 640 acres. So in this section 10, you have 640 acres, as we said. You go back, you hit the word of, and then you hit the northwest 1/4, so you divide by 4. Now you're at 160. Keep going, hit the word of, divide again. The south 1/2, divide by 2, now you're at 80. Now you come and you hit the word and, so you're going to stop. So the first parcel that you're describing has 80 acres in it. You're going to start over with the word and with another 640 acres. You're going to go backwards again. You hit the northeast 1/4, so you divide by 4. That gives you 160 acres. And you going backwards, you hit the word of again, you divide again by the southwest 1/4, that gives you 40 acres. So you have 40 acres in one parcel and 80 acres in the other. So legal descriptions are pretty simple. Just work backwards till you get the word section. Section, you know, you have 640 acres, and you're going to divide backwards unless you hit the word and, you stop and start over with another 640 acres. There are different types of leases that we'll talk about, and different types of estates. So earlier we talked about our freehold estates, and I said that's 1/2 of the chart, and we talk about the leasehold estates a little bit later. Well, here we are. So there's only 4 of them, and I'll go through these with you. Your estate for years actually has nothing to do with years. All it means is that you have a definite starting date and a definite ending date. You could have a lease from January 1st to December 31st. That's an estate for years. You could have a lease to rent a summer home from June 15th to June 19th. That's an estate for years. Definite starting date, definite ending date. And because it has a definite ending date, you do not need to give any notice to terminate an estate for years because you've already got the end date. Then you have the estate from period to period. Also, people refer to it as I'm on a month-to-month lease, something like that. So in an estate from period to period, you're staying and you're paying your rent at intervals, but you can give notice to terminate that lease, and so can your landlord. So let me give you an example. Let's say you've got a lease from January 1st to December 31st, and you pay your rent every month. And December 31st comes along and your lease is terminated, so you don't need to give any notice to terminate it, nor does your landlord have to give you notice. It's done, right? But you don't move. In January 1, you hand a new check to your landlord, they accept it and they cash it. By doing that, that's considered proof that they have accepted your periodic tenancy. So what you've just done here is you have created a new lease for the term of the original lease, January 1 to December 31. And as long as you keep paying your rent every month and your landlord accepts it, you keep going. But either one of you, by giving 30 days written notice, can terminate that lease. Now, if you stay past your expiration of your lease, it is also referred to in Illinois as a holdover tenancy. An estate at will means that you're staying with the permission of the landlord for an indefinite period of time. So let's say that someone is renting from their landlord and their lease expires at the end of the month, and they call the landlord and say, hey, can I stay a few more months until my new house is finished? I don't know when it'll be. It might be 3 months, 4 months, I'm not sure. They allow that to happen. So they're staying with the permission of the landlord for an indefinite period of time and still paying their rent at intervals. The next is an estate at sufferance. And in an estate at sufferance, think of it as everyone's suffering. Lease is up, you're supposed to move, landlord wants you out, and you don't leave. That's an estate at sufferance. Now, many people are under the misconception that if the building is sold or if the landlord dies that they have to move, that it will terminate their lease. The lease will not terminate on the death of either party, the landlord or the tenant, or the sale of the property. The new owner would have to take the property subject to the rights of the tenants. Most people don't realize that if a tenant dies, those leasehold rights, interests pass to their heirs as well. There's one exception here. In an estate at will, that's going to terminate on the death of either party. So when talking about commercial leases, those are usually pretty complex and have to be drawn up by an attorney. Your residential leases can, in many instances, the standard form contract can be filled in can be filled in and signed, but in a commercial lease, it's a little more complicated. So what will happen in many instances is that the parties will get involved in drawing up a letter of intent. So landlord and tenant and agent, if an agent is involved, and they will draw up a letter of intent. And this letter of intent will state all the terms and conditions that the parties want included in the lease. A letter of intent is not a binding contract. This letter of intent then goes to the attorney, and they use that information that has already been agreed to draw up the lease from. No money is transferred with a letter of intent. It's not binding. The lease agreement is. A couple of important things to remember about security deposits in Illinois. 25 or more units in Illinois, interest has to be paid on the security deposits. 5 or more units in Illinois, the landlord has to give the tenant an itemized list of all damages for which they will withhold all or part of the security deposit, and they have to give that to the departing tenant within 30 days. If they don't provide that to the tenant within 30 days, the landlord must return the entire security deposit within 45 days. That's on 5 or more units. Okay, you have assignment and subleasing. If you're going to assign your lease to someone else, they're going to take over all of your rights as a tenant. If you're going to sublease your unit to someone else, they also refer to that as a sandwich lease because you're kind of sandwiched in. The new tenant will pay the original tenant, who then pays the landlord. And the original tenant is responsible for all the payments as well as for any destruction of that premise. Long-term leases are leases usually for 3 years or more, and usually leases are not going to be recorded except for long-term leases. Those are normally going to be recorded. You may find non-disturbance clauses in some leases, and what this states is in the event that the property is foreclosed on, if there is a non-disturbance clause in that agreement, it will allow the tenants to remain in the property and now make payments to the lender or the bank whoever was holding the note. That way they don't get kicked out. A few more definitions. A gross lease. A gross lease is, most residential leases are going to be gross leases. All it means is that you make one payment to the landlord and they take care of all the other expenses. In a net lease, you pay a base rent and a portion of the other expenses associated with the unit or building. In a triple net lease, you pay a base rent and all of the expenses associated with the building. A percentage lease, you'll see that in some of the stores in the shopping malls or restaurants or whatnot. Base rent plus a percentage of your sales. A ground lease. A ground lease is for a very long period of time, maybe 50 to 99 years. Most of your shopping malls, your 7-Elevens, gas stations are on ground leases. So when someone enters into a ground lease, they're renting it for a long enough period of time so that it makes sense to erect a building on it, but because by the time the lease is over, the building would have depreciated. A lease purchase, different than a rent with the option to buy. In a rent with the option to buy, you have the option to buy it after your lease ends. In a lease purchase, it's a little bit different. You're buying it. You have a contract. The contract is your primary agreement, but you're just leasing it up until the time you close. In a sale leaseback, oftentimes companies will do this to free up working capital. If a company runs their business out of a building that they own and they need money, they might consider a sale leaseback where they'll sell the building to someone else with the provision that they're allowed to stay there and rent back from them and continue to operate their business. A couple terms here. Actual eviction. This is the process by which the landlord takes the proper legal steps to evict the tenant. And constructive eviction means that the tenant has to leave the premises because they are uninhabitable. Maybe the heat doesn't work in the winter or whatnot. In order for a tenant to claim constructive eviction, they have to leave. Okay, property management. In order to be a property manager in Illinois, you have to have a broker's license. And the first thing that a property manager would do when going to work for an owner would be to sign a property management agreement with the owner. And that property management agreement will spell out all the duties and the terms of the employment there. It'll spell out the compensation, it'll spell out what type of financial reports the owner is expected to receive, and the basic duties that the property manager will perform. A property management agreement is going to be signed between the two parties, and it is a personal services contract. It will terminate on the death of either party. So if you're a property manager and you have a personal services contract with the owner and the owner dies, you no longer have a job. That agreement is over. The ADA, Title I of the ADA provides for the employment for qualified job applicants regardless of their disability, and this applies to any employer with 15 or more employees. They have to provide accommodations so that people are able to do their job. Title III of the ADA prohibits discrimination in commercial properties and public accommodations. When acting as a property manager, you have to deal with risk management issues. When you come upon risk management issues, you have 4 options here. You can avoid it, you can control it, transfer it, for example, by an insurance policy, or retain it by determining that the chances of this event occurring are very slim and it doesn't warrant any other response. One thing you are not going to do is ignore it. And there are different types of insurance policies to protect against loss. You have fire and hazard, consequential loss, use and occupancy, contents personal property, liability, casualty, and surety bonds. Surety bonds will protect an owner or a property manager from criminal activities by an employee when working on their property. For example, if you hire someone to work on the plumbing in one of the units, and while they're in there, they steal the owner's jewelry. The owner wants to come back and sue you and the owner of the property. So the surety bond is what will cover you. You, as a real estate licensee, will not perform appraisal reports. Those are done by a licensed appraiser. And when someone does an appraisal, they're going to give one value. But you have to remember that whatever value that appraiser puts on that property, it is still just their opinion. You could have 3 or 4 different appraisers appraise the same property and get 3 different valuations for that property. Now, as I said, you will not be doing appraisals, but what you will perform are CMAs. And what a CMA is, it's a market evaluation on a property. You'll perform those for sellers that are intending to sell their property and for your buyer that is intending to buy a property because they want to see what you feel the value of that property will be. When you do a CMA, you're going to look at homes that have sold and closed, similar to the subject property, currently sold and closed within the last 6 months. You're not going to compare a 2-story to a ranch or a home in one suburb of Chicago to a home in another suburb of Chicago. You are going to get as close as you can in distance, in size, age, etc. And you're going to prepare a report based on what's sold and closed, what's currently on the market and is competition, and you're going to give advice to your client as to what range you feel the property should fall in line with. And you'll give them a range of values, but at the end, maybe from 195 to 200. But at the end of the day, if it's somebody that is going to list their property, it is the seller who is going to determine the asking price, and it's the buyer that is going to determine what they're going to offer for the property. Hopefully they take your advice and counsel. Now, there are 3 different approaches to determining value. The first one is the sales comparison approach. And this will be used by you as an agent and as well as appraisers. But what you will look at is the home that you're trying to determine a price for. That will be the subject property. And you're going to find comparables. Those are homes that have sold and closed currently, which means within 6 months usually. And you're going to come as like the subject property as you can get it, and you're going to compare them. So for example, if your subject property is a 3-bedroom ranch with 2 baths. And you're going to find 3 other 3-bedroom ranches with 2 baths, and you're going to compare, and they've all sold and closed. So you're going to compare each property. And if your comparable property that is already sold and closed has an amenity that is better than your subject property, you're going to look at what the comparable sold for and make adjustments in the price of the comparable. So think of it this way. If your subject property sold, or you have no price for your subject property, and your comparable property, your neighbor down the street, it's sold for $120,000, but they have a garage and you don't. Okay, are you going to get $120,000? No, you'll get a little bit less. So you need to deduct some money from what the comparable sold for to see what yours should sell for. Likewise, if your subject property is nicer than the comparable, you're going to make an adjustment there too. But what you're going to do is add money to what the comparable sold for to see what yours should sell for. So pretend it's your house and you're trying to figure out what your property is worth. Your neighbor down the street, house is pretty much like yours, except yours is a whole lot nicer. Yours has more amenities. Shouldn't you get a little more than what they sold theirs for? So if you have a positive amenity in the comparable, you make a negative adjustment in the price, and vice versa. Now, if you have a property that is very unusual and you have nothing to compare it to, or it's maybe a little church or a school, no comps, it doesn't produce income, or you have a very unusual house that you can't find anything to compare it to, you might want to use the cost approach. Agents don't use this very often, but appraisers do. So in the cost approach, you're going to take what it would cost to replace the dwelling. Okay, so if you have this existing dwelling, what would it cost to replace it? And normally what they'll do is they'll look at the square footage in the area and the price per square foot and apply it to this property. But this property is not brand new, so you have to deduct depreciation. That will give you the depreciated value of the property. But you're not done yet, because then you have to add in the land value. So it's pretty simple. For the cost approach, you take what it would cost to replace or reproduce the building, minus the accrued depreciation, and add the land value back in, and that will give you your value for the cost approach. Now, you have various types of depreciation that would be used in the cost approach. First one is physical deterioration. This can be curable or incurable. Peeling paint, a sagging roof on a 30-year-old house, that's physical deterioration. Curable means the cost to fix it would warrant the improvement. So yes, it would make sense to fix it. But let's say you have a building on the property that's run down and it's fallen apart and maybe it's worth $200. It's a little garage building or something, and the roof's sagging because of normal wear and tear. The cost to put the new roof on might be $500, but the whole thing's not worth a couple $100. It doesn't mean you can't do it, it just doesn't make sense. It would be considered incurable physical deterioration. You have functional obsolescence, which is an undesirable design feature. Good example, years ago people had large families and they'd have 5 or 6 bedroom homes and they only had 1 bathroom in them. Somehow back then that was okay, that's how they all lived. But in today's world, is that going to be functionally obsolete? You bet. Can you fix that? You can probably put some more bathrooms in there, yes. But if you have an office building that does not set up for central air conditioning and the cost to put that in would far outweigh the benefits, that would be considered incurable. Then you have external obsolescence. This deals with factors outside of the property, and no money that you put into the property will cure this. Maybe your home is near a polluting factory. It doesn't matter what you do, you cannot cure that. So those are your types of depreciation. Now you have the income approach. The income approach to value would be used for properties that bring in money, that bring in income. So let's say you have a 12-unit apartment building. The way that you would determine value on this would be, you'd come up with the gross income on the property, and that would include income from other sources. So not only your rents, but vending machines or washing machines on the property. That'll give you your total gross income. Then the appraiser is going to subtract an amount of money for vacancy and collection losses, which would be determined by what is going on in the area. That would be per the appraiser's judgment. And that will give you your effective gross income. So from that, you're going to deduct your operating expenses, the cost to operate the building. And that's going to be your management fees, that'll be your real estate taxes, that'll be your maintenance fees, decorating, repairs, etc. What you will not find in expenses are mortgage payments or principal and interest payments, because those are considered to be debt service and they are not included in expenses. So I'm going to show you this formula here. Call it our IRV formula. So the I divided by the R will equal the V, and the I divided by the V will equal the R, or the R times the V will equal the I. So in this scenario that I gave you, the annual net operating income is what you get by deducting your expenses from your gross income, basically. So let's just say that that comes out to be $30,000. Annual net operating income. That's the number that'll go into the I. The R is the rate of return. That's the cap rate. That's the rate of return that the investor wants to yield. So that will be determined by the appraiser as far as what is going on in the area. So let's just give you a number of 10%. So if the annual net operating income is $30,000 divided by 10% rate of return, the value on this building would be $300,000. Talk about zoning, a few definitions out of the zoning chapter. Non-conforming use means that a structure or a improvement is allowed to continue because it existed before the laws changed. So let's say you have a 4-story building and the zoning laws have changed to only accommodate 3-story buildings. You would be a non-conforming use. You'd be allowed to continue as a 4-story building because you existed before those laws changed. A conditional use permit would allow a use of a property in an area that is not otherwise allowed, like a daycare center in a basement in a totally residential area. A variance is an exception to the rule, and a variance will run with the land and pass on to owners, future owners of that property. Okay, now we'll talk about fair housing. Okay, so fair housing is an important issue, not only for information for this course, but as well as your real estate career. You have to make sure that you adhere to the fair housing laws. The last thing that you want to do is get in trouble for fair housing violations. So first thing, you need to know your protected classes. There are protected classes under the federal fair housing laws, and there are additional protected classes under the Illinois Human Rights Act. So each state has their own fair housing laws. Everyone has to adhere to the federal laws. You have to know these protected classes, make sure that you memorize them. So they are race, color, religion, national origin, sex, disability, and familial status, which means you cannot discriminate against anyone because they are a member of one of those protected classes. Now, a couple things here. There are no exceptions ever involved where race is involved. And there are no exceptions when a real estate licensee is involved in the transaction, and no discriminatory advertising is allowed. What is allowed, excuse me, is advertising for a gender-specific roommate, like male roommate sought or female roommate sought. Now, there are exceptions to these fair housing laws, except for race, except for real estate licensee and discriminatory advertising, for owner-occupied 1 to 4 unit buildings. So if you are an owner and you are occupying one of the units, you're exempt from these fair housing laws except for the ones that I just mentioned. However, once you get your real estate license, you no longer have any exemptions. So familial status means the presence of children. And this is anyone under the age of 18 living with a parent or guardian, and someone that is pregnant is also covered under familial status. Under disability, someone with a physical or mental impairment that prohibits some of life's major activities. A landlord cannot increase a security deposit for someone that has a disability that wants to make modifications to a unit, for example. So if a person with a disability wants to make reasonable modifications to accommodate their disability, the landlord's got to allow them to do it. The tenant has to pay for it, but the landlord has to allow it. They can't increase the security deposit for a person such as that. They, what they can do is they can negotiate as part of the agreement an escrow account, an interest-bearing escrow account with the interest accruing to the benefit of the tenant, to accommodate any restorations that might be needed at the end of the work, and they can also require that it be done in a workmanlike fashion, and all permits that need to be obtained are obtained. So you also have your Illinois Fair Housing protected classes. So you have all of the national protected classes: race, color, religion, national origin, sex, disability, and familial status. And Illinois is going to add some more on here. They're going to add on here age. And the age in Illinois that you are considered elderly is 40. So you can't discriminate against somebody because they are 40 or older. Not a lot of explanation for that. Marital status is protected. Ancestry, military status, and this includes favorable or unfavorable military discharge, sexual orientation or preference, and the last one that was added on in Illinois, it's probably been 11 years though now, is order of protection status. And what this means is that you cannot refuse someone because they have an order of protection issued against someone either in the state of Illinois or in any other state. So for example, if a woman wanted to rent a unit from you and she had an order of protection against her violent ex-spouse, you don't want to rent to her because you're afraid he's going to come around and cause problems. You can't refuse her on those grounds. You can refuse him, but you can't refuse her. She's protected. If there is a fair housing violation, it must be reported to HUD for investigation within 1 year of the alleged act. Blockbusting is illegal under the federal fair housing laws. That's inducing people to move out of an area because a protected class is moving in, and with the thought that because a protected class is moving in, that their property values will diminish. That is illegal under the fair housing laws, and more often than not, it is profit motive that will fuel the blockbusters. So they will scare people into moving out, buy their house for cheap, and then turn around and sell it for what it's really worth and make a profit. Steering, you cannot steer anyone to a particular area. Make your clients choose the area. Steering is one way that you can get yourself in big trouble if you try to choose an area for a client. Redlining is basically drawing a red line around an area and refusing to make loans or issue title insurance policies in those areas because of the racial makeup of the area. That pertains to your title companies and your lenders, and that is illegal as well under the fair housing laws. Talk a little bit about environmental issues. Asbestos. This was used because it was a fire-resistant property, and it was banned years and years ago, back prior to 1980, I believe. It was banned, and it was used in insulating materials because of it being so fire resistant. So if there's a property that has asbestos in it, it's not going to bother anything unless it's disturbed. So for example, you have an older building with floor tile that is going to be dug up. And if there is asbestos in there and they dig that up and those articles of asbestos become airborne and they're breathed in, that's when you have some serious health concerns. It causes mesothelioma. So if it is going to be removed, it has to be done by a specially certified technician. Now, two things you can do with asbestos. There's not a requirement to have it removed. You can have it removed by someone qualified, or you can encapsulate it, which means you seal it off so that it doesn't disintegrate and become airborne. There is no specific disclosure form for asbestos, but it all comes down to basic disclosure. If you know something, disclose. Lead-based paint was banned in 1978, so sellers and landlords are required to fill out a lead-based paint disclosure report form where they have to indicate, number one, whether or not they're aware of the presence of lead-based paint in a property, and two, if there has ever been testing done for the presence of lead-based paint, the results of those tests. This has to be filled out by the seller or the landlord and signed by the seller or the landlord, the buyer or tenant, as well as the agents. So the difference between this disclosure for a tenant and a buyer. Buyers have 10 days to perform risk assessments, in other words, to perform testing on the property for the presence of lead-based paint per the sales contract. Tenants do not have that same 10-day opportunity to test. So buyers and tenants are not treated the same with regard to lead-based paint. So it's important to remember that it is the responsibility of the real estate licensee to make sure that this law is complied with and that these disclosures are signed by all parties. In addition, the buyer, or in the case of a lease, the tenant, must receive a pamphlet. It's called Lead-Based Paint and You, and it outlines the dangers for exposure to the presence of lead-based paint. There is nothing that says a seller or landlord has to mitigate lead-based paint if it is present. The only time that by law that it has to be mitigated is if there is a child that lives in the property that has an elevated level of lead in their bloodstream. Then the Department of Public Health will come in and they will require mitigation at that point. Radon is the gas caused by decomposing rock and soil. And every area has radon at some point. Outside air levels are 0.4, and that is not a health hazard. If radon reaches 4.0 or higher inside of a dwelling, mitigation is suggested, but there's nothing in the law that requires one to mitigate for radon. So the problem becomes when you have a property and maybe you have the trapped gases underneath a home and they seep up through the basement, and oftentimes basements do not have outside ventilation, and so it gets trapped in there. And that's when it becomes a health hazard. Radon is the second leading cause of lung cancer. So there is a radon disclosure, not for rentals, but for sales, where the seller has to fill out, again, whether or not they're aware of any testing that has been done or elevated levels of radon. So the issue comes up if a buyer is purchasing a property and they have testing done for radon and it comes up with an elevated level, they can request that the seller mitigate that radon so that it's safe to move in. Seller doesn't have to do it, and if they don't do it, the buyer can get their earnest money and walk away from the deal. But if that happens, now the seller knows they have a radon issue, so they're going to have to fill out a new disclosure for subsequent buyers and disclose that they do have a radon issue. One other item with radon is because it is the trapped gases underneath a building that will rise through a dwelling. If you have a condominium level, second floor or below, you have to have the radon disclosure. Third floor and above, it is not required, because by the time that radon gases would emit to the third floor, they would no longer be a health hazard as they would have dissipated at that point. Next, we'll talk about RESPA laws. So RESPA applies to first lien residential mortgage loans to finance the purchase of 1 to 4 family homes, condos and condominiums, co-ops for investment or occupancy, and for second loans or subordinate liens for home equity loans when financed by a federally related transaction. Now, RESPA laws are aimed primarily at lenders, but real estate licensees fall under RESPA, under Section 8 under RESPA. Section 8 under RESPA has nothing to do with Section 8 housing. Section 8 under RESPA means that a real estate licensee is not allowed to receive a kickback or referral fee from a service provider because they referred their clients to use that provider. For example, an agent refers 5 clients to a specific lender during the year, and that lender is grateful and would like to give that agent something of value. Remember, compensation is anything of value. Money, bulk, game tickets, whatever the case is. It's illegal under Section 8. You cannot accept anything because you gave someone a referral, a service provider a referral. What is allowed is for a service provider to compensate an agent for doing something to earn the money. For example, the title company that you referred your client to use has asked you to run the documents for the closing downtown and they'll pay you $100. That's legal because you did something to earn the money. So no kickback or referral fees under Section 8. Section 9 says that home buyers have the right to choose the title insurance company that they wish to use. The seller cannot require them to use a particular company. They have the right to choose. And Section 10 requires lenders that lenders do not maintain excessive amounts of money in the escrow accounts. They cannot overcharge the client, the borrower, too much money to put into the escrow account to accommodate future tax or insurance payments. So they regulate that as well. Two things to remember about the TRID rule. There are two documents. You have the loan estimate, and the loan estimate has to be given to the borrower by the lender within 3 business days after their loan application, spelling out all the terms and conditions that they have agreed to in the loan. Then, 3 days before closing, the closing disclosure form must be provided to the borrower. And this closing disclosure form gives the exact amounts that they will expect to find at the settlement table. This allows the buyer an opportunity to compare the figures that they had originally received in the loan estimate to the closing disclosure to make sure that everything is as they signed up for. So make sure that you go over, there's not a whole lot of information on RESPA, but make sure you know what is up there. So that will conclude our review session. I wish you the best of luck on your exam and the best of luck in your real estate career. So make sure that you study, make sure you know your definitions, and repetition is really, really important to maintaining this material. So go over it, go over it, go over it, and good luck to you.